as you may know, it is compulsory. And just so that there is no confusion, the current trustee toolkit still has to be completed by trustees, and it will only not be required to be completed once we roll out the new trustee toolkit. Another question that we've been asked, more often than not, does it mean if you have completed the current trustee toolkit that you wouldn't be required to complete this trustee toolkit? That's indeed not the case. Even if you have completed the current trustee toolkit, you will be required to complete the new trustee toolkit. And just so that you have some understanding of the aim of the new trustee toolkit, it is to better equip trustees to execute their fiduciary duties. So it will be more comprehensive and extensive than the current trustee toolkit. So I hope that you know that there are many things that are learned today, and that it will also be something that should be seen as enhancing your capabilities in terms of executing your duties and not as a punishment. But as I said, it is compulsory in terms of Section 7A3 of the Pension Funds Act, read together with Conduct Standard 4 of 2020. So what we will do, as I said, we'll have the first 11 modules roll out next in 2023, and then the second tranche, which is the other 11 modules, will be rolled out in 2024. So in total, there will be 22 modules that will be completed. So as you can well imagine, it is something which is going to be quite comprehensive, and which we do hope that you enjoy. As you know, and many of you probably participated in the testing phase of the trustee toolkit. And thank you very much for that, because that, of course, is a very important part of the trustee toolkit development. As you know, as is this workshop, because I think that in this workshop, what we are trying to get across is the body of knowledge. So we'll be, many of the presenters will focus on the body of knowledge which was developed by various colleagues within our division, the Retirement Fund Supervision Division. So thank you very much, not only for the development colleagues, but also for those who are presenting today. So today will comprise 3 modules, as you may have seen, and module 1 will be the introduction to pension funds, or as I think the new term in COFI and the consequential amendments will be retirement funds. So we'll have the introduction to retirement funds, and the presenter will be Ms. Julia Masike. And the moderator will be Ms. Takalani Lukhaimane, and then there'll be that will be from 9:15 to 10:15. From 10:15 to 11:15, we will have the governance of retirement funds, and Tando Mbono in the fund governance and trustee conduct department in the retirement funds division will be presenting on that topic, and his moderator, whom I think many of you may be familiar with as well, is Mrs. Corlia Buitendag. Then that will be between 10:15 and 11:15. Then we'll have a tea break between 11:15 and 11:30. And then we will have module 3, which deals with the registration of retirement funds. Again, the new wording in COFI, the COFI legislation and consequential amendments to the Pension Funds Act will be the licensing of retirement funds, but as well as rules, registrations, and rule amendments. And that will be done by, the presentation will be done by Silindile, Sebotsa, and the moderator will be Johan van Vollenhoven. So on that note, colleagues and trustees and principal officers, I hope that you find this to be a riveting sessions, and the format that will be followed is that the presentation will be more or less 50 minutes, and there'll be 10 minutes for questions. But please, feel free during the process of the presentation to drop questions. The speakers, of course, the presenters and moderators will attempt to respond to your questions. If it's not all covered, if you can just, also we will then consolidate a Q&A and send you that at the end, I think at the end of probably of day 4 of the workshops. But on that note, trustees, principal officers, and colleagues, I hope that you really enjoy day 1 of our trustee training toolkit workshop. And Sancha, over to you. Thank you.
Thank you, Zarina, for that opening address. Good morning, ladies and gentlemen, and welcome to day 1 of the Trustee Training Toolkit workshops. My name is Sancha Pitri, and I'm from the Retirement Fund Governance and Trustee Conduct Department. I will be the one facilitating the next 4 Trustee Training Toolkit workshops. And I just really want to thank everyone for attending today. We really appreciate it from our side. Before we start, just a few housekeeping rules. I have disabled everyone's mics and cameras except for the presenters and moderators. This is just to mitigate any accidental interruptions. The presenters and the moderators will attend to your questions after their presentation. So if you have a question, please pop it into the chat box. I will be checking the chat box and ensure that either the presenter or the moderator attends to your question. If you prefer to speak to it, you can just raise your hand and I will then enable your mic, and then after which you should then unmute yourself. Without further ado, I would like to hand over to my first presenter, Ms. Julia Masike, and her moderator, Ms. Takalani Lukhaimane. Thank you.
Thank you so much, Sancha, and good morning, ladies and gentlemen. Sancha, may you please send, or may you please show the presentation? In a presentation mode, preferably. Good morning, ladies and gentlemen. My presentation is on Module 1 of the Trustee Toolkit, as mentioned by Sancha, which is Introduction to Pension Funds. And the presentation will cover the following contents. Can you please move to slide 4, Sancha? Thank you so much. The presentation will cover the purpose of a retirement fund, the difference between a pension fund and a provident fund, what a hybrid fund structure is, and I'll also look at the defined contribution structure and a defined benefit structure. We'll look at the difference between an umbrella fund and a standalone fund, and we'll also look at what Regulation 32T of the Pension Fund Act says about participation in a pension fund, and lastly, we'll look at the different types of retirement funds. We get the definition of pension fund. Can you go to, yes, thank you, Sancha. We get the definition of pension fund and its purpose in Section 1 of the Pension Funds Act in the definition of pension fund organization. And paragraph A of the definition of pension fund organization defines a pension fund as any association of persons which provides annuities or lump sum payments upon retirement of a member or a former member, or upon death, and which benefits will be payable to the dependents of such members. Now, in the context of a pension fund, an association of persons usually involves an employer-employee coming together to form a retirement fund or a pension fund, which can either be a pension or a provident fund. And the purpose of that particular fund will be to provide annuities or lump sum benefits when it will be upon retirement of a member, but now it also provides for situations where the particular member or former member might have died, and that benefit will then be paid to the dependents. I also want to say that the definition of a member in the pension funds is that any person who has a benefit in the fund is regarded as a member. So that's why you see it's payable to a member or former member upon their retirement. Next slide, please, Sansha. Now, paragraph B of the pension fund organization defines a pension fund or pension fund organization as any business carried on under a scheme or an arrangement which provides annuities or lump sum payments for the benefit of persons who belong or belonged to the class of persons upon their retirements or upon their death, and which benefit will be then payable to the dependents. Now, if you look at paragraph C, the definition of pension fund, can you go to, the definition of pension fund in paragraph A and B, they are more or less similar, but obviously there's a difference in the type of fund that is defined in paragraph A and the type of fund defined in paragraph B. In paragraph C, a pension fund organization is defined as an organization of persons or business which receives, administer, invest, and pay benefits in terms of the employment of a member on behalf of the beneficiaries, payable upon the death of a member. Automatically, you think of a beneficiary fund, which is a fund that is established to benefit the beneficiaries of a member upon their death. Now, it goes on further to say it includes any association or business which carries on business in connection with any of the objects specified in paragraph A, B, and C, also carries on business in connection with any object or friendly society. A friendly society is a non-profit association of persons which provides relief or maintenance to members of the association, either when the member dies, either when the member gets unemployed, either for the purpose of providing education to the children of the members. Can you go to the next slide, Sansha, please? Just to recap, now, if you want to see whether a fund that you participate in is a pension fund organization, you have to ask yourself a couple of questions. The first question is the what? Sansha, can I see the content? Yes, thank you. The first section, the first question that you ask yourself, what is it? Is it an association? Is it a business, or is it a scheme? The second question that you ask yourself is, Sansha, can I see the content of the screen, please? First, ask yourself, what is it? Is it an association, a business, or a scheme? Secondly, what it provides, the purpose for which this particular fund is established for. Does it provide retirement benefits, or does it also provide retirement benefits and death benefits? What benefit is provided for this particular fund? And you ask yourself, who are the parties involved in this type of fund? Who are the parties involved or participating in this particular fund? Is it the members? And is it also to benefit the beneficiaries, who will also be the parties in this particular fund? The last question you ask yourself, when does the benefit provided in this fund become payable? Does it get payable upon retirement of a member, and also upon the death of a member, which benefit will be paid to the beneficiaries in terms of Section 37C of the Pension Funds Act? Registration of pension funds. Pension funds are registered by the FSCA, the Financial Sector Conduct Authority, in terms of Section 4 of the Pension Funds Act. And in terms of Section 4, subsection 3 of the Act, if the authority is satisfied that the registration of the fund is desirable in the public interest, the authority may provisionally register the fund. And provisional registration is valid for a period of 5 years, and thereafter the fund can be finally registered by the authority. And you'll notice that when you apply or send the rules to our to the authority, they will then be stamped as an indication that the rules have been registered. And in addition to that, the next slide, please. In addition to that, the particular rules or the particular fund will be approved by the South African Revenue Services in terms of Section 1, and the FSCA currently has a limited delegated mandate to approve funds in terms of Section 1 of the Income Tax Act. And what happens is, after the fund has been registered, you will, in addition to getting the stamped rules, get an approval letter that indicates that the fund is now approved in terms of Section 1 of the Income Tax Act. Registration in terms of Section 4 of the Pension Fund Act by the authority, and approval in terms of Section 1 of the Income Tax Act by the FSCA due to, or as a result of the mandate that we've received from SARS. Now, the difference between a pension and a provident fund. Both a pension and a provident fund are established to provide retirement benefits to members. Now, what is the difference between them? Now, the difference is in relation to commutation upon retirement of a member. Now, we have a position pre the 1st of March 2021, a position post the 1st of March 2021. Now, pre-March 2021, in a pension fund, on retirement, a member was entitled to commute 1/3 of the benefit in cash, and the balance could be used to purchase an annuity. There was compulsory commutation. And in a provident fund, a member had an option to commute part or take the entire benefit as cash. Now, you ask yourself, what is the position after the 1st of March 2021? Now, the position for pension funds remains the same, meaning that pension funds still provide for compulsory annuitization. Now, for provident funds now provide for compulsory annuitization for vested rights. And if you ask yourself what vested rights are, means benefits that accrued pre the 1st of March 2021. And the vested rights may be committed for cash. Next slide, Sansha, please. We look at the difference between a defined contribution and a defined benefit fund structure, and we'll also look at what a hybrid fund structure looks like. So a defined contribution structure means that contribution going into the fund are guaranteed, and I mean a pension fund, are guaranteed, and it's typically a percentage of a member's salary each year or annually. And the pension is dependent on the investment performance, because obviously the contributions going into the fund will be invested by the board, and the employee bears the investment risk. Now, in a defined benefit, what happens is that the contributions coming out of the pension fund at retirement, remember, in a defined contributions, we said the contributions going into the pension fund are guaranteed. Now, in a defined benefit structure, the contributions coming out of the fund at retirement are guaranteed, and this is typically a benefit of a percentage of the employee's salary. Now, who bears the risk in a defined benefit structure? Since in a defined contribution, it's the employees who bear the investment risk. In a defined benefit structure, it is the employer that bears the investment risk, or rather the company that bears the investment risk. Next slide, please. Now, we also have a hybrid fund structure. Hybrid fund structure is basically a combination of a defined contribution and a defined benefit structure. And previously, a lot of funds opted to have, like, you find a fund being a defined contribution structure, but having also a hybrid structure for those employees or members of the fund who join the fund at a particular date. So a lot of funds now, majority of the funds that we regulate are actually defined contribution funds, but we still have funds that are defined benefit, and we also have those funds that are hybrid funds. Now, what is the difference between an umbrella and a standalone fund? Where do we get that from? Regulation 32T tells us about participation. It says that participation, it says that the rules must provide for a specific indication of the participation in the pension fund so as to differentiate between the different types of fund. And it says that a fund that is established for the benefit of employees of a principal employer and its subsidiaries. Now, this definition refers to a standalone fund. And if you want to see what an employer structure of a standalone fund looks like, basically you have a holding company which holds a stake in company A, company B, company C, and will establish a fund. This fund will be for the principal employer, which is the holding company, and also its subsidiaries. So then there's a relation between this particular employer and the subsidiary employer. So the subsidiary companies is that the principal employer or the holding company owns a stake in company A, company B, company C. There is a relation or association between the employers. Now, paragraph 2 of Regulation 32T, it says a fund established for the benefit of employees of various employers that are not related. Now, if you look at what we have on the slide of the presentation, we have a non-profit organization, a mining company, an audit firm. The nature of these businesses are different and the employers are not related. And this is what we refer to as an umbrella fund. And we've got two types of umbrella funds, and I'll also talk about them later during the presentation. So this is called an umbrella fund. The various employers participating in this particular fund are not related. Regulation 32T3, it says a fund established for the benefit of persons not referred to in either subparagraph 1 or 2 above, meaning that are not referred to in a standalone, that we're not talking about a standalone, we're not talking about an umbrella fund. So there's no connection by employer. And examples of these type of funds include a preservation fund, which allows for transfers of benefits from other approved funds. We have a retirement annuity fund where there's individual voluntary participation. And we have a beneficiary fund, which is established for the benefit of minor children. We also have an unclaimed benefit fund, which allows for the transfer of benefits into the fund, which are unclaimed benefits. And I'll touch on these types of funds later in the presentation. Now, Regulation 32T2 spoke about an umbrella fund where the employers are not related. Remember, we had a non-profit organization, we had an audit firm, we also had another employer that is not related to those. Now, we have two types of umbrella funds. We have type A umbrella fund, type B umbrella fund, and in a type A umbrella fund, there are general rules for the fund, and there are also special rules for each participating employers. Now, a fund will be registered in terms of Section 4. They submit rules, and they'll also submit special rules for each and every employer that participates in this fund. What do we find in the special rules? We find eligibility requirements or criteria, which indicates who's going to participate in this type of fund or under this employer. We also find contribution rates where we can see how much the employer is contributing, how much the member is contributing. And in some special rules, it's only the member contributing and not the employer. And we also see from the special rules the type of benefits that are offered to the member. This will be retirement benefits, death benefits, and all those benefits or disability benefits, any benefit that is provided for this particular member participating under this employer will be stipulated in the special rules. Now, in a type B umbrella fund, we have the general rules that are applicable to all employers. And what happens is these general rules will also have the eligibility provisions or criteria, which indicates what type of member or who will be participating in this particular fund. We'll also include the contribution rates for a fund that wants to make a differentiation in relation to contribution rates. For an example, if the NPO, the nonprofit organization, wants to contribute 7%, the general rules will indicate that for this particular employer, maybe a class will create a class for the NPO to say the nonprofit organization is a category A and they'll contribute so much. And the audit firm or the accounting firm will be referred to as category B and they'll contribute this much. The general rules will also indicate what benefits are payable to members, and the benefits will include retirement benefits, disability benefits, and death benefits. Now, we have different types of funds. We have occupational funds, and these are funds that are established by the employer. They are established either as a pension or a provident fund. There's employer-employee relationship, and it's for the benefit of employees. For example, I'm the employee of the FSCA, and we have a fund called the FSCA Pension Fund, and I contribute into this fund. This fund was established by the employer for the benefit of the employees, and it also stipulates, and in the fund, we'll also get to understand what benefits are payable to employees upon their retirement, their resignation, their retrenchment, and death. We have preservation funds. And earlier on, I said in a preservation fund, preservation funds allow for transfers of benefits from other approved funds. Preservation funds are established as either pension preservation or provident preservation. They are designed or established to preserve, the purpose of which is to preserve retirement benefits. So you'll not find a person who is employed and say that I am employed and my employer contributes into a preservation fund. No. For example, I belong in a pension fund. If I resign, I choose to have my benefit in this fund as a paid up member, and that particular benefit can also be transferred into a preservation fund. So it's designed solely to preserve retirement benefits. There are no recurring contributions, as I've said, and it has tax-free transfers. An unclaimed benefit fund. An unclaimed benefit fund is a fund that it can be established either as a pension or provident fund. It is established to receive unclaimed benefits. And in terms of the definition of unclaimed benefits, that refers to benefits that are not claimed within 24 months of them becoming due and payable. Then such benefits, the fund then can choose to either, if provided, emphasis, provided that the rules of the fund allow for those benefits to be transferred to an unclaimed benefit. For example, the rules of the fund will say if we have unclaimed benefits in the fund benefits that are not paid to the members within 24 months of them becoming payable, we can keep these unclaimed benefits in the fund, and it is the responsibility of the board to trace and pay those unclaimed benefits. If the fund then choose to have these unclaimed benefits transferred to an unclaimed benefit fund, then the board of that particular unclaimed benefit fund has a duty to trace and pay unclaimed benefits. We have retirement annuity funds, and I said earlier that there is individual voluntary participation in this particular fund. It is established to provide income. There's voluntary participation. As a member of the FSCA pension fund, I can choose, so to boost my retirement or for whatever reason, I can choose to be a member of a certain retirement annuity fund where I'll be contributing monthly. I choose the contribution amount that I want to pay into this particular retirement annuity fund. And that particular contribution that I'm making in this particular retirement annuity fund, obviously the monies will be invested and I'll get my benefit upon retirement or the benefit will be paid to my dependents or my beneficiaries upon my death. We have beneficiary funds. And a beneficiary fund is basically a fund that is established to receive, to administer, to invest, and to pay death benefits. And these death benefits will be payable to the beneficiaries. They're not payable to a member, they're payable to the beneficiaries because the member has died. And it allows transfers of death benefits from other approved funds. And it's for the benefit of minors and beneficiaries incapable of managing their own affairs. And the benefits in this particular funds are held until the minor reaches the age of majority. There's also, this type of fund allows for monthly payments and ad hoc payments that can be made to the guardian of a minor. That is before the minor reaches the age of majority. Are there any questions?
Sorry, I see there is a hand from Nasadine Govender. Thank you very, very much, Julia, for the presentation. There were a few questions in the chat, but I think we've attended to some of them. Perhaps, Sancha, if you could unmute the person who has their hand up, Ms. Govender. Thank you.
Ms. Govender, I have enabled your mic. If you could
Yes.
unmute yourself.
Okay,
Mr.
good morning.
Mr. Apologies.
Good morning. Can you hear me?
Yes, we can.
Yes, we
Thank
can hear
you.
you.
Good morning. Thank you very much. Firstly, let me appreciate the informative presentation. However, I'm just checking something because I've noted that in terms of the type A special rules, where you say that the employees will contribute but not the employer. I'm just checking. I've also put it in the chat box, but I'm checking, is it ethical because it's a retirement fund? The employers have an onus to cater for retirement for the employees. Would it be correct and ethical for an employer not to contribute and only the employees to contribute? I'm just checking that. Thank you very much.
Sancha, could you please just go back to that part of the slide so we can just quickly see that type A, type B comparison, please? And Julia?
Yes, Taki. So we remember now I'll just give a practical example. A fund was registered and both the employer, let's say type A fund was registered, an umbrella fund was registered, and the special rules of this particular employer were registered, and it provided for the contributions for both the member and the employer. However, due to COVID-19, the employer is experiencing some financial distress and then decides to send an amendment to the rules to now reduce the contribution or say that they will not be contributing due to the financial distress. Now, we really can't say it's unethical for this particular employer because the practicalities really would be impeding the employer to be contributing in the fund. So I think it's only fair that if the employer finds himself in that particular situation where they cannot afford to pay contributions, however, the members are still getting a salary and they can still afford to a certain extent to contribute towards their retirement, they're allowed to do so. So I feel in that particular instance, would have a special rules providing for only member contributions and not the employer contribution due to financial distress. And I wouldn't view those special rules as being unethical.
Yeah, so I think that is I want to say an extraordinary circumstance, and probably just as an example that you can, in your special rules, then provide for particular circumstances. And you'd know during COVID we did then issue a communique saying that funds could reduce their contributions. That is definitely a negotiation between the members and the employer. And so by the time it comes to us, I think it was just, an example to say, look, this is what could go into your special rules. But contributions from our side in terms of the rules is what is negotiated between the member and the employer, and that comes from their employment contract. Remember, in terms of the Income Tax Act, your participation is, unless, of course, you're an RA or preservation fund, is due to your occupation. So by the time it comes to us for registration, we are of the view that by then, it has been negotiated between the member and the employer per their contract. And so to us, it wouldn't come into an ethical question, more that by then we are of the view that they've already discussed it as an employment contract matter, and that would be a labor matter and not necessarily a pension fund matter for us to consider at that time. I hope that answers your question. Of course, we'd love to see contributions for everyone.
Thank you very much. I think you have answered my question, because on the basis that it's subject to the negotiation between the employer and the employee, and it's for special circumstances. Because I think the crux of the matter is to keep the employee in the job rather than worrying about retirement only. I'm answered.
Thank you. Thank you. I see Angie from Sakau has a question. Perhaps we could unmute her, Sancha.
I've enabled your mic, Angie. You can unmute yourself.
Thank you very much. And once more again, let me echo the same sentiments of welcoming the report that is more informative. I just want to check on the issue of unclaimed benefits, because at some stage you find that the fund is under administration, and during the time of administration's number of discrepancies happens when members are leaving, some are dying, but you find that number of things because they were unable to be located due to change of residential addresses. What happens if at some stage a member comes back and say, I was not contacted and I did not have information as to when I leave, because some they may abscond and the employer keeps mum that an employee has gone, and the fund or the administrator of the fund did not communicate to the member to say, where are you, what is happening? Is it possible that the fund can change the rule in relation to unclaimed benefits if a member comes back and say, I'm here, I'm still alive, I'm looking for my money back? What will be the legislation saying in that regard? Thank you very much.
So Angie, sorry, Sancha, don't mute her immediately. Angie, thank you for the question. I think you've now touched on a very passionate issue for us on unclaimed benefits. But when you're saying, how would you want to amend the rules? If I could just understand that portion.
I'm raising this because you find that the previous person who was responsible with the running of the fund in the absence of trustees was not clear as to what transpired in transferring the unclaimed benefits to a different institution or administration. Then it becomes unfortunate you don't even have a handover report to can make those follow-ups. But you find members coming back and say, I want my money because when I left employment, I absconded and nobody contacted me within the 24 months to say, hey, come back, here's your benefits, come and claim that. But the unfortunate part is that the administration by that time that was run by a curator, for an example, has transferred those monies and did not even take keen to look for those members to come and claim their benefits.
Okay, thank you for the question. So in relation to trying to trace a member, because we realize that the current regulations or the previous regulations, as at the Regulation 33, which provided for what an employer must actually give to the fund in relation to a member, didn't have contact details. So you almost had to rely on the employer for contact details. And some employers would close down, and you wouldn't actually have the contact details. So we've now issued a conduct standard that relates to contributions and receiving of contributions. An employer must give you, as a fund now, they must give you the telephone number of that person, their address, their email address if they have it, so that you can at least try to contact that person. I think what has been making tracing of members also difficult is that funds are not collecting individual unique information on behalf of a member. So as a trustee now, I would encourage you to look at the data that you have and look at whether you've got ID numbers, because that is the most unique thing that you can use to try and go to any place to try and find this person. We also recognize the problem that when there was a transfer or in terms of tracing activities, funds did not actually record what kind of tracing activities they did. So you're right, you don't have a record of what would have happened prior or what took place with that unclaimed benefit, and it is an industry problem, so not necessarily isolated to your fund. We will, and I think from engagements that we've had, we've also identified that perhaps we need to have more engagements on the unclaimed benefit funds as well, or unclaimed benefits, to make sure that we have a consistent approach in industry on how to deal with them. So in your rules, you need to provide for what is it that the fund wants to do, and it's up to you as trustees. So, we've got the definition, but if you want to provide for specific things for your members, then they're your rules, right? So as Julia would have highlighted in her presentation, we register them, but as long as they're not inconsistent with the Act, you can provide for what you believe would be in the best interest of the members in those rules. But you can try to work with those funds where the monies were transferred to try and trace those members as well, because you know your members best, you know your employers best. And so you might actually be best placed to also provide that information. But Angie, I'm very willing to have an offline discussion about it as well. More than welcome to have a discussion with the board about the unclaimed benefits. It's one of my pet projects as well. So I would be happy to set up a meeting for us to go through what the difficulties the fund is having and what we can do. Is that okay, Angie? Oh, okay. Sancha, I see there are 2 hands from Johannes. I don't know if it's 2 hands or there are 2 Johannes.
Johannes, I've enabled your mic.
Hello.
Hello.
Yes, it's Emmanuel Koji. Johannes is my colleague. We are sharing the screen here. So can I pose my question?
Yes, please.
Can I come with a question?
Yes, please.
And then secondly, I would like to, when I finish with the question, then maybe to comment on the tracing issue. Ma'am, my question is that in the presentation, it was mentioned the tax-free transfer. I'm not sure which transfer we are referring, as we got a section 14 where the government, I mean, the ruling says the money can be transferred from one A position to the B position. So also you got a member who will waiting his money to be deposited to his bank account, That is also a transfer. So I'm not sure when is the tax-free is available. Thank you.
So I think that was in relation to the transfers to the preservation funds. And where you are transferring, in the position that I have as the last time, where you are transferring from a like to like. So if you're transferring from a provident fund to a preservation provident fund, that is a tax-free transfer. So it was only in relation to that she was just mentioning sometimes people then also take advantage, or rightfully so, of the fact that it would be a tax-free transfer if you're transferring from like to like into a preservation fund. You will still get taxed when you leave the preservation fund and ultimately take a benefit, which would be an annuity or a third or whatever the benefit that's provided from there. But that initial transfer from the occupation fund to the preservation fund, from a like to a like, so provident to provident, that would be tax-free. That was sort of the little highlight in terms of tax that she was mentioning as well.
Thank you very much. Now, I just thank you very much. I'm clear now. Still Emmanuel Koji. I just want to make a comment, if it's not a question, in this matter of the tracing. I think any company in South Africa is battling with that. I'm not sure is our country alone, but we still need to be taught about this, or maybe we still need to think more, how can we avoid this or to prevent this matter? I know that it's all over from the government point of view, whatever private companies, it's something that is there. Now, can't maybe we come with proposals and saying, instead of waiting for a member to pass on, can we do something while the member is still present? That if something happened about that employee or the member, it's going to be easier for us to find where he is or where she is. And then this is the way we are going to use in future to avoid this kind of a problem. Is there anything or nothing can we do? Thank you.
From the industry side, we have seen some solutions, but there are more system solutions that have been drafted by companies outside the FSCA and that we don't work with. But in terms of where you can actually deposit information for a member, so members can freely go and put their nominations and their information, so that it becomes easier even for family members and yourselves as funds to try and either trace them or to trace their former members. But that's not necessarily a solution, I suppose, for the fund. I think what's important is to try and make sure that there's constant, if not regular, communication with members. And hence I was mentioning the fact that we have now put in the conduct standard that, we want cell phone numbers, we want you to have the member's address and information. But I believe that we need to do a lot more in terms of financial education to members and their beneficiaries. We need to do a lot more in terms of showing people the consequences of not updating those nomination forms. And we need to make sure that as funds and as boards of trustees and even as the regulator, that you are not waiting for a long time and unnecessarily to make payments. So as I said, we need to work around this unclaimed benefit situation. And I think, please, if you've got a proposal, please share it with us, so that, as you would have heard, we've heard system solutions that aren't even ours as the FSCA, but we're open to hearing solutions that can definitely mitigate against unclaimed benefits going forward. It is a very big issue at the moment, and it's not necessarily historical. And so we do need to find solutions. So if you've got any, please, our door is open. do come and let's have a discussion about it as well.
Yeah, ma'am. Thanks. I think you give me a light of in future what I mean. Somebody can follow the advice from what you raised. The last comment I want to make is that we all seen what had happened in Natal. You know, that disaster of during that time. Now we may find that more than 5 members of the family, you know, is involved in that tragedy. So we may find that, okay, a member, a principal member, and the family as a whole are no more. And those are the people who are very, I mean, very important to assist after the disease. But now it's something that is not going to happen every time, but it's something that we have to also to bear in our mind that can also be one of the events that can give us a problem. Thank you, ma'am.
Thank you very much for that example. I think that's a very pertinent one, where in our discussions as well, we're trying to also make sure that we discuss these matters with the Department of Justice to make sure that where you need to open estates and all of that, that the people are educated about that as well, and there's an easy process in order to do that. And we can see how prevalent those kind of situations are so that we can come up with solutions for them as well. But that is a very serious issue and a pertinent one as well. Thank you. Are there any other questions, Sancha? I'm now only looking at hands in the participants box. I did see, and I was actually trying to now respond to a section 13A query that was posed by, is it Tertia? And I was actually busy with it now, but I will continue to respond to it, Tertia. I think you've raised a very serious issue, and we are having webinars on section 13A as well. I just need a few more details from you so I can see how I can assist you, but also try and bear in mind that we are working on solutions to try and assist the entire industry to make sure that people can open cases easy enough. But I do apologize for your experience at SAPS, and I will just post a response to you in the chat as well. Thank you.
Thank you. There are quite a few questions in the chat box. Let me just see if I can get through some of them. Will these webinars be available as a recording for those trustees who can't make it attend today? Yes, Vishani, we will be, the workshop is being recorded, and we will make recordings available. The next one, will the new toolkit be required to be completed within 6 months of it becoming effective? Yes, Philip, it will be required. It is mandatory for trustees to complete the new trustee toolkit, and for those who complete the previous toolkit. So even if you have completed the previous toolkit, you will have to complete the new one as well, because once we launch next year, the new toolkit will replace the current toolkit that is there. So trustees will then have to complete the new toolkit within 6 months. Lynn van der Merwe, these workshops were scheduled at a very short notice. We do apologize for that, Lynn. We will be making recordings available for those who could not attend today. Is the entire content spread over the 4 workshops? Of the 4 workshops, or the workshops are simply spread to cover the number of trustees and principal officers? In other words, the trustees and principal officers need to attend all 4 workshops. Brian, yes, it's not mandatory to attend these workshops. It's just an informative session for when we launch next year, so that trustees are a bit more comfortable with the toolkit. As Arina has mentioned, there are 22 modules in total. The first 11 we will launch in 2023, and then the next 11 we will launch in 2024. So right now we are just doing workshops on the first 11. Sure. There are quite a few comments. And I do see that Sarina is attending to some of them. I think I underestimated how many people will be attending today. So I think if you have a really important question, could you please raise your hand rather? I know that Zarina and I've seen Corlia and Takia are responding to some of the questions in the chat box, but if you have a pressing question right now, could you please just raise your hand?
Yeah, I think most of the questions are in relation to one, whether the presentations will be available, and I think you've already, dealt with that. The others are, in relation to the unclaimed, which Zarina and I have dealt with. And then the one other question I think that perhaps Zarina and yourself can attend to is whether the current trustees would have to new trustees would have to complete this toolkit, or will they have to only complete the current toolkit? I think perhaps you can attend to that, but I think based on the effective dates, that might give us an answer, but perhaps you could just give a definitive answer for that as well.
I could. So the current toolkit is still very much in place, and trustees have to complete the current toolkit. Until we launch the new toolkit, which then will replace the current toolkit, they will also have to complete the new toolkit. But I see Zarina's hand is up. Zarina, if you'd like to.
Yeah, so I just wanted to respond to Lynn's question. So Lynn, yes, this is, we are having these workshops now, but we will certainly have these workshops again. And as Sancha has indicated, it's to basically orientate or sensitize trustees and principal officers to the content, of the new trustee toolkit, so that it doesn't seem like a bit overwhelming, I think, once we launch. So that is really the aim. So to answer your question, this is, it's not the only workshops / webinars that we'll be having. But Sancha, I think let us give the attendees the opportunity to ask questions. I see there are more hands. Thanks.
Let me just allow Neil's mic. Niels, I have enabled your mic. Please unmute yourself. Oh, Niels has put his hand down. If there are any other questions, please raise your hand and I will enable your mic. Niels. Oh, Niels has raised his hand. Your mic is enabled. Please unmute yourself.
Hi, could you please tell us if these slides are going to be available? I'm not interested in working through the workshop for 5 days or 4 days. I don't have the time for that. I've got the time to sit and work through the slides in my own time. Will they be available?
Niels, thank you for that question. Yes, the slides will also be made available to participants.
Thank you very much for that.
And then Chris, let me just allow your mic. Chris, you can unmute yourself.
Yes, hi. In future workshops, because these are quite close together, will the modules be run in the same format? So I could attend today and then maybe in 3 months' time, the second module in another session, and then the third module in another session. So, spread over the different periods. So, because I can't do all 4 days in this short period of time. Will the modules be the same each time? All right.
Zarina. Hi, Zarina.
Hi, so yes, I hope I'm not erroneously sharing my screen, but anyway, yeah, so Chris, you could do that, but we may not have, four more sessions. So I think what we did think about was that we'll have this, and we realize at short notice, as Sancha says, we apologize for the short notice, but we are thinking of having this again. early next year. So probably 2 more of these sessions. So Chris, it won't be 4, but as I think has been explained, these workshops / webinars will be available as recordings. The presentations will be available. So you have the option of either, I think, attending 2 maybe now, and then 2, the early part of next year, or have access to the recordings or presentations. I hope that answers your question.
Okay, thank you.
Chris.
I don't see any more hands. Oh, okay, there's another hand. Let me just enable your mic, Lazarus. You can unmute yourself. Lazarus, you can unmute yourself.
Yes, I think I am unmuted.
There you go. Yeah.
There's something that I always wanted to find out, especially when you look at the definition of pension fund organization, paragraph A. It says that it's an entity that provides, I think, annuities on retirement or benefits on death. So what I wanted to find out is it possible to have a fund where you have members who are only participating for risk benefits?
Hi, Lazarus. How are you?
I'm fine, in you.
I'm good. No, it's the initial one is that it must be retirement benefits. Remember, we used to have those benefit funds,
Yes.
way back when. I don't want to comment on how far way back when because I'm not really sure. But those are the primary function is for it to provide. And remember, the one thing that I think I've been stressing in the chat is also you need to read it together with the Income Tax Act. And you will find that for those definitions, it starts, although ours as pension fund organization has got those 3 paragraphs, in the Income Tax Act, it starts off, and you must read it together. So it starts off with occupation, it starts off with contributions, it starts off with it's for retirement benefits. So it won't be approved, 1, not by us because the objective is not for retirement funds, and 2, definitely won't be approved by SARS either.
Yeah, it's just that,
yeah,
the concern is that when you look at the Pension Funds Act, it says
yes,
it says providing annuities or benefits on death. So it suggests that when it comes to FSCA, the FSCA can register the fund that is providing risk only. But I understand what you're saying. Basically, you're saying when it comes to approval, there might be a problem.
Yeah, it's annuities in relation to a pension benefit. Remember, when you retire, then you get an annuity. So it's not an annuity in a risk benefit sense, no.
Yeah, but I'm just saying the definition in the Pension Funds Act. It says it's a fund providing annuities on retirement, and it says or, it doesn't say and.
Okay.
It says or benefits on death, which means that when you're looking at the definition in the Pension Funds Act, it suggests that, for registration, you can have a fund that provides risk only. But I understand what you're saying. It means you're going to have a problem when you then apply for approval, for tax purposes. Then it might not go through, because it do not comply with the Income Tax Act. I understand that. Yeah.
Lazarus, it's in relation to, there are 2 things that are provided in the definition. It will either be on retirement or on death of that member, right?
Yeah,
and obviously on death of the member, but we can take it offline. I think on death of the member, the fund needs to pay a benefit. It's not risk.
Yeah, because it doesn't say and, it says or.
Okay.
Which means, when it comes to registration, it means that for registration it can go through.
All
But
right.
you might have a problem when it comes to approval, because the definition in the Pension Funds Act, it says it's a fund that is providing annuities on retirement, and it says
All
So
right.
it says,
No,
it
I
says,
see where you
it
are,
says,
yeah.
yeah, it says it's either retirement or benefits on death. It doesn't say
All right.
end.
Okay.
Yes.
All right. No, I understand what you're saying. All right. I do.
All right. No, thank you.
Thank you. Sancha, I don't know whether that was for Mr. For Chris, if that is an old hand or a new one.
I think it's a legacy hand, Chris. Unless, let me see.
Sorry, Sancha, but you're quite faint. I don't know if it's just my experience or Takalani. Is Sancha quite faint?
I've actually upped my mic a bit every time Sancha speaks because I thought it was just me as well. Sancha,
I am a bit fluish right now, so my voice is
okay.
not the greatest, but I'll try to speak a little louder. Chris, I've enabled your mic if there's something else you would like to add. I don't know. I think we have addressed Chris' question, so yeah. And I don't see any more hands. So I think we can move forward. Oh, I see a hand from Zarina. Zarina?
Yes, Sancha, I'm just also thinking, before we move on, if there are trustees or principal officers or colleagues on the line who feel that their questions have not been answered, maybe this is also an opportunity to, just put up your hand as well. I know there were some questions around fees related to unclaimed benefit funds, etc. I did try to respond and say that, look, there is National Treasury is looking at establishing, in terms of legislation, the Central Unclaimed Benefits Fund, which ought to take care of those concerns such as fees and, I think tracing concerns and so on. But I think, Sancha, maybe just before we move to allow our colleagues to pose questions if they feel they haven't been adequately addressed in the chat. Thank you.
Okay, Zarina. If there's anyone else who would like to pose a question, please just raise your hand and I will enable your mic. Okay, Angie. Angie, you can unmute yourself.
Thank you very much, Zarina. I think I am comfortable that we should have a side conversation, because it's a very long story to tell, so that whoever is going to guide us as a board, we have a lengthy discussion and give a full background of where we're coming from and what create all these questions that the answers are difficult to find by the board members themselves. Thank you so much.
Angie, I have noted your email address. I will then arrange a meeting with you. We're actually in the middle of meetings with the funds where we felt that they had the most unclaimed benefits, and trying to do more, I want to say, deeper analysis into some of the challenges and issues that we might have, and also issues from the fund side. So we are setting up, or I have set up meetings with those funds as well. And I do see a lot of the questions are in relation to the unclaimed benefits. So I do think that perhaps it is necessary for us to perhaps engage on it as an issue on its own as well. Okay. Sancha, I don't know if Chris's hand is an old one or a new one.
Allow his mic again.
Okay.
Chris, you can unmute yourself. No, I think it's a legacy.
I think there was a question in relation to the unclaimed benefits. I have answered it on the issue of what is the administrator's responsibility in terms of record keeping. The Act says that it should be that the trustees have given consent on whether they can destroy those records or not, how long to keep them. It is a gap in the Pension Funds Act where we don't have a time period for how long those benefits must be kept, or how long the record must be kept. But it's really up to the trustees at the moment to have a record keeping policy. And I'm yet to see one from a fund, to be honest with you, to say, we will keep any benefits where we have paid a member for the next 3 years or for the next 5 years. But without adequate data or without proper record keeping, there is a lot that can go wrong in a fund. And so it's very important, because even for us, when members approach us and say, the fund says they paid me, but they can't prove that they paid me. It would be a lot easier to answer that member if the fund could then produce some policy or document saying this is what we would have done. And that is currently not available. And if there is a fund that is in this training, or an administrator that is in this training that has got that kind of document available, then please do raise your hand and let us know. But I'm yet to see one where formally record keeping is discussed between the administrator and the fund. Yeah, so I see Mr. Whitaker is saying that it is the fund's retention periods of various information typically set out as part of the POPIA policy requirement, but that's also fairly recent, Philip. So, it does become problematic when we're discussing someone's benefit from 1990, which is what we are receiving now. Like I said, I'm yet to see a record keeping policy from any administrator where it's actually discussed with the fund and signed off with the fund. And that is what is also causing members a big frustration, because they come to us and they say, well, as a FSCA, how can you not be regulating or know where these records are? So yes, Estelle, I understand it, and believe me, in terms of, Estelle has just said the board must guide the administrator, but there's nothing guiding the board from a regulatory perspective. So thank you. When we do issue lots and lots and lots of guidance in the next coming years, you will understand why, because it won't just be guidance in a regulatory form, but just guidance in terms of us discussing what could be best. I see there's a lot of unclaimed benefits, Sancha. I'm definitely going to have to organize with you an unclaimed benefit webinar or discussion. But I think we can definitely look at something there. We're still busy with our 13A ones. And then we will, from the information that we get from our meetings and other engagements that we'll set up one-on-one with the funds, we'll then make sure that we discuss the unclaimed benefit issues going forward as well. Okay, Sancha, I think from a moderator side, from my session, we might be done. I'm creating a new session on unclaimed benefits, and I don't think that will be good at all. So I'm ready to hand over back to you. And thank you very much for the opportunity from myself and Julia. And thank you for everyone's questions. Okay.
Thank you, Taki. Thank you very much, Takalani and Julia, for your insightful session. I hope trustees are now more aware of the direction that we're going in with the toolkit, which is to ensure that it's more comprehensive and updated, especially updated, because trustees really need updated skills and knowledge in order to effectively exercise their fiduciary duties. So thank you so much, Taki and Julia. We are now moving on to the second session. So I will now hand over to Tando Mbono, who will be presenting on governance of pension funds, and moderator Corlia Buitendag.
Morning all. For those who don't know me, I'm Corlia Buitendag and I'm the head of the Retirement Fund Conduct Supervision Department, and I'm joined by Tando Mbono, who will do the presentation. Tando is an expert in the industry. He worked for a retirement fund and also at the Office of the Pension Fund Adjudicator. After every module, I will ask him a question just to make the session a bit interactive, and kindly leave your questions until the end and then we'll address it then. Thank you. Enjoy the session.
Thank you, Corlia, and thank you, Sansha. I don't know if I'm an expert, Corlia. Feels like you're setting me up for a harder four.
You're keeping me out of jail.
But anyway, good morning, ladies and gentlemen, and good morning, colleagues. It's a big topic, fund governance. It's a lengthy topic, both in terms of scope and in terms of the significance of the topic. It covers. I just made a mess with my table of contents. If I may be allowed, just to tell you, just from my notes, what is going to be covered, because it's not in front of you. So we're going to be talking about the role and purpose of the board, the objects of the board, duties of the board, liability of board members, exemptions in terms of Section 7B, minimum skills and training, requirements for board members, the appointment of the Section 26 board, principal officer, and we'll complete with treating customers fairly. So just at the outset, if I may just make a declaration here that I made a mistake with my references, because I did them in footnote form, and I realized that they were not looking too neat on the slides. So they are not on the presentation, but they are on the original document. So lest I make myself guilty of plagiarism for not acknowledging my sources. If I may just do that, I'll just give you just an overview of the sources that I've consulted, the people who are the actual creators of the knowledge, the brain workers who come up with the substantive material. I've looked at commentators like Hunter and their co-authors, Hanekom and their co-authors. Some of the material comes from the OECD papers and the King report, I think. So some of the case law that is involved and is used as authority for the propositions I put forward, where I can remember them, I will cite them appropriately. So, as I was saying, it's a very big topic, and I must admit it's a rather intimidating topic for what appears to be a formidable crowd. I know that trustees and principal officers are not a homogeneous group, that you can pinpoint the level at which you can pitch your presentation, but we battle for the middle ground. And to the extent that some of the concepts that are here dealt with may be elementary to some of you, please bear with me. I do not presume to pontificate or talk with any measure of condescendence over you. It's just that trustees are a mixed bag in terms of the knowledge gaps, and one struggles to pitch it appropriately. I personally, as Corlia has said, I learned at the feet of some of the most, seasoned trustees and principal officers cutting my teeth in Auckland Park with the comrades there. So I understand, and I hope you bear with me. So right off the outset, I would like to just start with a definition of what governance is, as put forward by Fiona Stewart of the OECD and her colleagues there, who say that the governance of pension funds involves the managerial control of the organization and how they are regulated, including the accountability of the boards of management and how they are supervised. The basic goal of pension fund governance regulation is to minimize the potential agency problems or conflicts of interest that can arise between fund members and those responsible for the fund's management, which can adversely affect the security of pension savings as a remunerative promise. If you could just page down, Sansha, or is it paging up? So good governance has many of the positive spin-offs, such as creating trust among all stakeholders, reducing the need for prescriptive regulation, conducing to more effective corporate governance of the companies that they invest in, as well as manage pension funds more effectively, to seek value for their investments. Good governance also needs to be risk-based. In case you were getting scared that I'm going to be reading to you throughout, I am not. I just thought perhaps to capture it correctly, I must read it directly from how it was written by the source. So, ladies and gentlemen, in preparation for this presentation, I have had an opportunity just to scan the international jurisdictions in pension fund regulation and just check what are the trends that are prevalent in the industry abroad and in South Africa through the IOPS, OECD, and other standard setting bodies. So particular lessons that come through and that are you're betraying a trend in fund governance and the issues that beset the industry. As I read the authorities, it seems to me that it's the issue of knowledge gap amongst the trustees. And another prominent feature is the issue of conflict of interest. Of course, there are other things that the authors point out, but those two in particular are of paramount importance, which is why I think it is commendable on the part of our colleagues at the FSA to address the question of trustee training, to bring trustees up to a level where they can feel confident to run pension funds, which are multi-million organizations, almost without exception. So it is in that spirit that we try and address these issues. So I'm going to be referring to the governance issues that are outlined in the Pension Funds Act, and perhaps try and unpack some of the concepts that are usually thrown around in pension fund speak without people paying particular attention as to what they mean. And I know Corlia is very big on meaning and the definition of words. So let's begin. If you could page down, Sansha. So as you know, that among other instruments or among the provisions of the Pension Funds Act, we have for now, I think, PF Circular 130, which deals with governance of retirement funds, and that outlines, the nitty-gritties and the nuts and bolts of fund governance. And I must admit, having looked at the international studies, I realized that it is cited quite often as a reliable guide, though it is well known that it is not a binding document but a guidance of the authority. But I think it sets out a very clear guideline on how funds are governed. So basically, in the preamble of the document, I think the emphasis is the fiduciary relationship between the fund, the member, and the board. And it also makes an emphasis on the character or the fitness and propriety of board members for them properly to execute their fiduciary duties in relation to the fund. So if you could page down, Sansha. So right at the beginning, let's talk about the appointment of the board.
Tando, before we go on, can I maybe ask you just, I've got some questions that I would like to address to you. You mentioned in your introduction, you mentioned about that the basic goal of governance is to minimize a conflict of interest. Can you maybe just as example, what is a conflict of interest?
Yes. Thank you, Corlia. The best way to, in my view, to understand conflict of interest conceptually is to say it is when somebody allows his duty, all right, which you would in this case have towards the fund, to be superseded by a personal interest that is outside of the interest of the principal on behalf of whom he is acting. That is what you mean by a conflict of interest. If I could give you an example, for instance.
Yeah.
If I give you an example, Corlia, if you have employer appointed trustees, for instance, who also occupy senior positions within the employer and make decisions on behalf of the fund at the employer level, it stands to reason that the duty that he owes to his employer and that which he owes to the fund will come into tension at one point or another. So that is what we mean by conflict of interest. And thank you for that, because you see, sometimes because concepts are not properly defined, it is easy to see conflict of interest where it does not lie. Yeah.
An interesting thing that you mentioned about the definition of IOPS, Fiona Stewart. She indicated in a definition that good governance needs also to be risk-based. What do you think she means about risk-based?
All right. Risk-based is, I think it's a methodology or a regulatory model, Corlia, that is adopted by supervisory authorities. I think it's of recent use. I think it dates back to about 2005, thereabouts.
Yeah.
Where the disposition towards the risk is at the forefront. It is about the early identification of risk, for instance, in organizations, and in this case in funds, and putting mechanisms in place to mitigate against that, and depending on the risk profile, for instance, of the organization in question, then you decide the intensity with which you can apply or follow up on that particular regulated entity. So in the case of fund governance, where funds are risk-based and they have control mechanisms that they've put in place, which is also a requirement of Section 7D, I think, and some of the OECD guidelines, that the mechanisms must be in place to anticipate and guard against the risk. So if you succeed, what Fiona Stewart is saying is that if you as a fund, you minimize your risk through good governance, you are likely to keep the regulator at bay. For the regulator to look after other people who perhaps may have a higher risk profile than you know, pursuant to your good governance.
Yeah. No, and it will also give a trustee a better understanding of the fund and the type of risks that they're facing. So I actually like that that definition. Tando, before we go on this one, as you said, you know, I'm very pedantic about the meaning of certain words. Maybe. Can you tell me what is fiduciary responsibility? You know, for us that's not legally qualified. What is that word fiduciary? Because it comes through the acted legislation, and when we take regulatory action, we usually mention that you haven't adhered to your fiduciary responsibilities. What is a fiduciary responsibility?
All right, thanks, Corlia. Fiduciary responsibility or duty means a duty of loyalty. In this case, it would be a duty of loyalty owed by the board to the fund. And that duty entails a predisposition to put the interest of the fund ahead of anyone else, including yourself. All right, and I know that there are commentators, for instance, who question as to whether the board actually owes a fiduciary duty to members, given the fact that members and the fund's interest may come into tension sometimes, and you find them with split loyalties. So, but the court, I think, has put the matter to rest in Lawrence versus Tech, that members and the board, and the fund, are owed a fiduciary duty by the board. So if you gain improper advantages, Corlia, by virtue of your position in the board, and you have other interests that you, or other benefits that you gain by virtue of your board membership, you are in breach of that duty, because you shouldn't use your position to derive benefits that are not then passed on to your principal, which is your fund in this case. And in that case, you would be in breach of your fiduciary duty, and if there's loss, for instance, that can be shown by virtue flowing from your actions, then the board can sue you for that. But if there is no loss, for instance, it is able to disgorge the profits that you made, or if you earn fees, for instance, you would be liable to refund the fund, because you would have gained extra advantages by virtue of your position, which were not with the consent or were not transmitted forward to your principal, which is the fund. So that's what it means.
Thank you for that, Tando. I appreciate.
All right. So thank you, Corlia. If then we shall plow on. We talk about, because I wanted to build it from the ground and deal with the appointment of board members to the fund, and the mechanisms by which that happens, and the rights that vest in the employer as a stakeholder and the members as stakeholders in the fund. So Section 7A deals with the rights of members to appoint board members, at least 50% of that board complement, and the minimum is set at least 4 board members for a fund to be properly constituted, and then half of those must be appointed by the members, and the other half may be appointed by the employer. So what we say there, Corlia, is that the right on its own is meaningless if the employer or the fund does not make positive steps to facilitate the exercise of that right by the members. All right, so setting up elections and seeing to it that there are nominations and that sort of thing. I think this is something that you know best. It's more your stomping ground. So that right is given effect to by either the board or the employer, that members must exercise their rights. But it is true that in certain circumstances, members may waive their right, for instance, to elect board members for whatever reason they may have, provided the rules of the fund allow for it. Because I think the court said in Bezeno Note versus AAA Mutual Fund that any right that is conferred by statute can be waived by the person for the benefit of whom it was enacted. That is, of course, assuming that the right is not in the general public interest, in which case you cannot do it because it does not only affect you. But in this case, members will be the people that are affected by that right, and the waiver thereof will only affect them. So I think we recently had a case in point, as a matter of fact, of members that were, for practical purposes, not able to exercise that right, at least on the version of the fund. And we asked the fund to procure those waivers, but properly advising them as to what is at stake. Obviously, there has to be an exemption after the waiver has been made. The FSA has to exempt the board from having a provision that makes the 50% board complement appointed by members who are exempted in terms of Section 2, sub 5, for practical purposes, if those are the reasons, or 281 of the FSR Act. Yeah, so it is a waivable right, but it is waivable by the people to whom it belongs. I mean, I have an example, Corlia, of a fund where the municipality manager just upped one day and said, we have decided to appoint a task team to run the fund. We're no longer interested in the board. The task team will be appointed by me and my colleagues, and it's going to run the fund. So it just betrays the amount of ignorance that is out there in terms of what the rights of members and the obligations of employers and funds versus those members are. So yeah, that is that about the appointment of the board and the rights that vest in members to appoint them. If we could proceed, Sansha. So yeah, this is the crux of the issue. This is what brings us here at Section 7A, subsection 1, which enjoins members of the board to attain levels of skills and training that the FSCA may gazette, and those skills must be attained within a period of 6 months of the board member having been elected by the members. So skills and training and the competence that flows therefrom is in my view an element of the fit and proper test. As you know, that there's fitness and then there's propriety. One concerns itself with competence, and one concerns itself with character. So board members must attain these skills within a period of 6 months having been appointed, and that is why we have the trustee toolkit, which I think was deliberated upon quite at length in the earlier session. And also section principle 12 of circular 130 makes provision for training that must be rigorous, and the subjects that the members of the board must be trained on, so that they can effectively discharge their duties towards the fund. If you could go down, Sansha. Yeah, so those are the areas that members must vest themselves in, by way of rigorous training, which will be offered in addition to the Trustee Toolkit, not limited to the Trustee Toolkit. And I know that there have been criticisms, for instance, at the PLA and from other colleagues about the toolkit, and people are saying, how can you be competent in 6 months? Isn't it a futile exercise? And what we emphasize is that because we have lessons from elsewhere, as I said earlier, where this model is very useful, and we've been getting some positive feedback to counter what other detractors are saying. But really, the point, as we will see later in this presentation, the point is not to make trustees experts in law, or to make trustees experts in tax, or in actuarial, or whatever discipline that insinuates itself in the daily administration of a fund. But it is to help trustees attain a working knowledge of these issues, a working knowledge that is sufficient for trustees to have an educated assessment of the kind of advice that they're getting, for instance, from experts in various disciplines of their professions in relation to the fund, so that trustees are at least fully equipped and are not bamboozled by suits that will talk over their heads. And I was saying earlier that the OECD notes, for instance, that of all the countries that have been surveyed on fund issues and governance, the study that was done for South Africa, it's an old study. It may very well be a new development, I don't know. But as it was at the time, some of the things that were pointed out were the conflicts of interest that are occasioned by the experts, the consultants, who have, between whom and the trustees, there's a very vast knowledge gap, and they can bamboozle trustees into all sorts of investments and other issues that are beyond their reach. So that is where we are, ladies and gentlemen. It is what the FSA is attempting to cure with an exercise such as this. If you would page essential for me. So as I said, the object of the board is not to micromanage the daily activities of the fund. It is not to do the daily workings of a fund, because trustees are otherwise gainfully employed and do this thing on a part-time basis. And some staff members, some funds would have their own staff where they are self-administered, and they will do the actual legwork and the spade work that is necessary for a fund to run. But the point is to direct, control, and oversee the fund in accordance with applicable laws. So the body is therefore the mind of the controlling mind of the fund, not necessarily that there would be hands-on on a daily basis. They're answering phones and paying claims and counting contributions, that sort of thing. So the applicable laws that the board members must be versed with is the Pension Funds Act, it's the FSR Act, it's the Financial Institutions Act, it's the Income Tax Act, it's the Divorce Act. So if you are governing a fund in accordance with the applicable laws, it follows that you must know what the applicable laws are, or at least have a decent working knowledge of what those laws are for you properly to function in a fund. Proceed, Shansha. Oh yes. So in the pursuit of the board's duties, the board has a duty to protect the interest of members that are already in the rules. The rules that provide for those interests. It is the board's job to see to it that those interests are protected. And some commentators, for instance, say that duty does not mean or entail actively to promote interests that are not already provided for in the rules, because those are the jobs of the unions and the wage setting and workplace forums and people like that. But it imposes a duty on existing rights or interests that are already enshrined in the rules, and it puts a very strong emphasis on such things as the Section 14 transfer, during which the board's duty is at its most acute, because members there are vulnerable when funds are transferring out of one fund to another, and you find that perhaps they will be in a worse off position if they were to transfer and they were to resign immediately after the transfer, and sometimes they may not gain the majorities necessary to object to the transfer. But the irony of it is that if you have been looking at the case law and the litigation that has been going on in the country, it is one of the most litigious issues about which funds are fighting between each other, the interests of members. I mean, the transfer of members, assets being thrown all over the place, tossed around from this administrator to that administrator, tossed around to this fund to that fund, appeals and counter appeals. In circumstances where the Act specifically puts emphasis on, the duty and the heaviness thereof in respect of this transaction when the change of business is shifting from one employer to another, and also in terms of the reduction of contributions by the employer or the increase of contributions by the employer, the board is expected to be at its most vigilant. So in addition to that, board members must act with due care. And their due care entails prudence and caution consistent with one managing the affairs of another. That is what due care is, that you must not be just nonchalant about transactions that you perform on behalf of members as monies whom they have placed faith in you and nominated you to sit on those boards. And also the boards have a duty of good faith towards members, which means doing the right thing for the right reasons. Absence of improper motive, honesty of intention, and exercise of unfettered discretion. And among others, because I could have burdened the document, ladies and gentlemen, if I put everything that duty entails. But among other things, it is, especially when you talk about doing the right thing for the right reasons, it encompasses using the powers that are conferred on the board by the rules for the purpose for which they were intended. That's the duty of good faith. And colleagues would know that in the past, there has been a prevalent attitude by pension funds colluding with employers to abuse Section 37D, for instance, which allows members' benefits to be withheld, but subject to conditions as set out in that section. but you notice a trend in terms of which this is weaponized by boards colluding with employers. It's actually the other way around. It's the employers colluding with boards that are, supine and suggestible to the whims of the employer, and using this section, people going to the adjudicator to complain, and board members instituting or employers instituting trumped up charges on criminal charges just to hold on to members' benefits. That is not in keeping with the duty of good faith that members are owed by board members. And also the exercise of unfettered discretion. And I'm sure my colleagues will uncover it, will cover it more in 37D as 37C, for instance, where when you have a discretion to exercise, you cannot have a predetermined criteria that is unshifting, that you say, I exercise my discretion and I always come to this conclusion. So you have to have an unfettered discretion that is unencumbered by preconceived notions of what you might do if a certain situation might arise. So further, as we've spoken about conflicts of interest, and that the interest of the fund or the duty of loyalty to the fund by the board must always prevail over the interest of a board member, because personal interests do arise. It's easy to think that they won't, but once you sit there and you are in charge of a big fund and suddenly you have certain powers, you realize that you are a different person than you thought. So further, the other duty that you have there is to act with impartiality in respect of all members, avoiding unfair discrimination among members and beneficiaries. But of course, there may be circumstances in which fair discrimination may be rational. You may be allowed to discriminate if there are proper grounds on which you are discriminating, but it must be fair discrimination. It must not be unfair discrimination. So if I could give you, for instance, an example of what an unfair discrimination would be and what a fair discrimination would be. Say, for instance, in the case of risk benefits, I know some delegates have spoken about risk benefits as being the conceivably the only game in town for a particular pension fund. So if you have a category of members or categories of members, different categories of members, in respect of whom different benefits are conferred, especially in relation to risk benefits, you realize that the cost of funding their risk benefit will be determined by their risk profile. Some people may be blue-collar workers, some people may be white-collar workers exposed to different dangers and the risk of the insured event having varying probabilities of occurring. So in that circumstance, you may be justified in saying that a risk benefit premium, for instance, for this category is that or is that, depending on what the people who crunch these numbers quote you. But there are instances of clear unfair discrimination that just cannot be justified. And if I could just tie that with the affected discretion and talk about unfair discrimination. Certain funds, for instance, have, when they say distribute benefits, risk benefits, they have a certain predisposition towards or negative disposition towards people of a majority age, children of a majority age. I know of instances where a fund would say he's 21 years old, he should be working by now. And as a result, we get less or little. And that is a discretion that has already foregone the circumstances of this particular child. And it is discrimination on the basis of age, which achieves no rational purpose to the reason that it is taken for. So that is what we mean by impartiality among beneficiaries. And then we'll talk about the Act talks about acting independently. This is a more contentious point, which perhaps I would like to put a strong emphasis on, that board members have a duty to act independently and think independently. Though they act as a collective body in the fund, but the thinking process that is involved is independent thinking. There's no room for groupthink. And they are not accountable to the people that elect them. They are not accountable to the people that appoint them. Once they are sitting on the board, they represent, or they owe a duty of loyalty to the fund and to administer it in terms of its rules. They cannot have mandates coming from members. They cannot have mandates coming from the employer. And this, ladies and gentlemen, is decided law. The court put this matter to bed, I think, in the matter of Papao versus Sepao, I think, pension fund. Papao is the pension fund, Sepao was the union, where the fund took issue at being given instructions and mandates that come from resolutions that were outside of the fund to carry out. And the matter went to court, and the court correctly found, in my view, that board members owe a duty of loyalty and a fiduciary duty to the fund. They cannot act on the basis of mandates coming from outside because they're not representatives of members or representatives of employers. They are board members. Of course, if they abide by their duties and they run the governance of the fund properly, the natural spin-off from that is that the members will be taken care of. The remunerative promise that was made by the employer to the member will be realized as a spin-off of the board members doing their job, acting independently, exercising independent discretion, owing the highest duty to the fund. So that is what we mean by that. Let's go on, Sansha. So I had that earlier in our earlier session. There was talk about keeping of records and the duration for which they may be kept, and the purpose for which those may be kept. And I think Taki was correct in that, as you can see, this is section 7D. It doesn't say for how long those records must be kept. It doesn't say, but I may be speaking under correction. If colleagues would recall this, I'm sure in the engagement session they will set me straight. I seem to recall that Circular 98 did provide a guide of some 5 years, but I don't know if that circular is still prevails. But I think that's what I seem to recall, and it sets out the kind of information that must be kept. But I think that period of 5 years is where it comes from. But of course, it's a guide by the regulator. It's not the law that binds funds. And the benefits of keeping records are self-evident, ladies and gentlemen, throughout the life of a fund. That's why you have the chaos that you have when there are transfers, people talking about reconstruction of data, people not being properly traced, and all sorts of things that happen. People say we have changed administrators for so many number of times because of this. And when you are supposed to trace former members for Section 15B and all of that, you are at a loss. So for however long the consensus may be that these records must be kept, it is incumbent upon the board to keep proper records, minutes books, that must be kept as outlined in the regulation, and that sort of thing. Shall we, Sancha? So the other thing is, which ties back to the question of risk-based, governance, is the keeping of proper control systems within the fund, and the communication of members' rights and benefits. I think Circular 86 talks about that. The regularity of communication. I think the Act sets out a period of 6 months following the end of a financial year, during which the principal officer must send members the rules of the fund that have been amended, and their benefit statements and that sort of information, increases in contributions, and also that responsibility is more important in terms of our conduct standard 1 of 2019, I think, where member communication is prescribed in respect of transferring members from one fund to another, and the benefit comparisons that may flow from that sort of information. So it is statutory requirement. It is important that members of the board must know that. Please proceed, Sancha. So this ties in with section 13A, I think, in respect of payment of contributions, that the board has a duty to ensure that those contributions are paid timelessly, and it says they must take reasonable steps. Reasonable steps have been interpreted by the first adjudicator to include instituting of civil proceedings, for instance, against employers. Board members cannot afford to sit on their laurels, and I know this is more like his stomping ground, and then wait for the member to retire or to resign and tell them that we haven't received your contributions for the last 2 years. When there's a statutory obligation for members to be informed and reasonable steps to be taken, in furtherance of that obligation. So the duty of the board further is to ensure that the rules and the operation and administration of the fund comply with this Act, the Financial Institutions Act, and all applicable laws. And applicable laws I interpreted there to exclude the common law in terms of the Interpretation Act. But perhaps if I may just put emphasis on this point of ensuring that the rules and the operational and administration of the fund comply with the Act. And you know, Corlia, that you and I and other colleagues were just wrapped over the knuckles by our General Counsel just the other day, when he said, tell your boards to read their rules. They must know what is in the rules. And I convey that message, ladies and gentlemen, that in order for you to ensure that the rules comply, you must first know what the rules are, and then you must know what the Act says in compliance with which those rules must be. Now, what happens is that board members, as a matter of habit, not all, but just as a matter of habit, don't know the rules of the fund. What they do, they wait for a problem to arise and use the board, the rules as a reference point. Let's go check what the rule says, and pick up that one rule out of the entire set and say, no, this is what it says. It allows us to do this, and then close the rules, and you look at them again when there's a controversy about some issue or another. And when in fact the rules of the fund are supposed to be the board members' gospel. I'm not saying you must recite them off by heart, but by all means, if you could, because ladies and gentlemen, the reason why that is important, I've seen it, and I've seen so many tears because of board members picking up one rule and relying on it, running to town because they say this rule says this, and it allows us to do this. And I saw a fund getting very humiliated because they misinterpreted their own rule. And then when they come back to us, they say, but we acted in terms of this rule. Because they don't know the entire scheme of the rules, they are unable properly to interpret what that specific rule means in relation to the others. So we only had to read the rules to know that the interpretation sought to be given to what the fund was attempting to do was contrary to the rules. You read Rule 3, it appears to be plausible, the meaning that you confer to it. Then you go to Rule 5, which expounds on Rule 3. Then you realize the meaning that you sought to ascribe to the Rule 3 is incorrect. So if it cannot be emphasized more, and you will be very pleased to know the power that comes from knowing your rules. I mean, if you watch parliamentary proceedings, for all it's but the one thing I like about those guys, they have the knowledge of the rules of the institution they operate in, which is what the fund should succeed to emulate. Then we can talk about the law, which you must know, and other relevant things. But the rules are drafted by or at the behest of the board. It's one of the few organizations that actually has a say and takes a resolution on the rules that govern them, what must say. Attorneys don't have that privilege, advocates don't have that. They abide by rules that are already drafted by somebody else. The boards sit and make resolutions, and those rules are drafted at their behest. But you find that boards are on a piecemeal basis in terms of what the rules say. And whenever there's the issue, then they will page through and appraise themselves of the contents, which is not in keeping with the duties of the board. Shall we, Sancha? Oh yeah. Then, ladies and gentlemen, it stands to reason. I mean, you only have to say to understand it that the board cannot do everything in the fund. It just cannot be that you will do every single thing. You are allowed to delegate. You're allowed to delegate some of your duties in consistent with the rules of delegation contained in your set of rules. That delegation must already be provided for you to delegate some of your duties to other people like service providers, subcommittees, and that sort of thing. But I think the authorities were in agreement prior to the insertion of subsection 2, I think, to 7D, as I recall it, that the delegation of duties exclude discretion-based decisions. For instance, 37C, where it is the discretion of the board member personally that must be exercised, which you cannot convey to somebody else. But I think that is a moot point now, because that section 7D sub 2 says any duty may be delegated, subject, of course, to the proviso that the board is not relieved of its duties. It does not abdicate its responsibility, but it delegates, and it becomes a tricky question as to what is abdication and what is delegation. And I think Cameron in the Law of Trust places the distinction between those two as to where the responsibility ultimately attaches for liability if things were to go wrong. So though you may delegate your duties, but you may not shift away the liability that may flow from the actions of your delegee, and you may not relieve yourself of the duty to monitor by way of reports, by way of some such accountabilities between you and your delegee. So that is where the distinction lies in the responsibility ultimately should something go wrong. Sanja? All right. So board members, which is why education is important. Which is why board members must be trained and must train themselves and upskill themselves to get to a level where they can be comfortable in making decisions. Because there is that minor issue of liability for breaching your fiduciary duties. And it would be in bad form if members were to be appointed to the board and we send them as sheep amidst the wolves, knowing that there is a liability, personal liability in certain circumstances for breaching fiduciary duties. But obviously, fiduciary duties are sui generis in nature. In other words, they are neither, or the breach thereof, intention-based or negligence-based. So, and the fund can only get duties as against the fund in circumstances where there is a proven loss on the part of the fund. Otherwise, the fund will be able to recoup whatever profits you've made in breach of your fiduciary duties and that sort of thing. So, like I said, that with respect to experts, board members have the ultimate say, and you cannot say I was relying on legal advice, therefore I'm absolved. At least that alone is not a defense for its own sake. Obviously, when we read Section 7F, it will come to light. So you must have relied on legal advice, but your reliance thereon must have been reasonable. You must have acted prudently. And it's hard to know what legal advice is or some other advice when it's going over your head. Sometimes people can make things that are not right sound right, and you won't know where to start. So which is why a reserve base of knowledge is necessary so that people can apply their minds to the sort of advice that they get, because there will be no defense if you just slavishly followed what the lawyer said or what the actuary said or what Zibaniwani said. So Section 7F sub 1 says the following: in any proceedings against a board member in terms of this act, other than for willful misconduct or willful breach of trust, the court may relieve the board member from any liability, either wholly or in part, on terms that the court considers just, if it appears that the board member acted independently, ladies and gentlemen, honestly and reasonably, having regard to all the circumstances of the case, including those connected with appointment of the board member, it would be fair to excuse the board member. So the court there has a discretion. That's why it says it may relieve, either in full or in part, depending on the circumstances of the situation. But the proviso being that you must have acted independently, must not have been carrying on a mandate, must not have been consulting in a caucus, and you acted reasonably. That is, there's a justifiable reason, a logical connection between what you did and the reasons you did for it, and it is proportional to what you did. Not that you were honest, or you were sincere, or you were not that sort of thing. there must be reasonability in your actions, and there must be independence, which I cannot harp on more about. Thank you, Sansha. Just a second. Ladies and gentlemen, I don't know if Corlia, I don't know how much time I have. This is a very long module, and it encompasses other modules that on their own could be modules on their own. I don't know, as I understand.
Yeah, there's we've only got 10 minutes left, Tando, and I don't know if people want to allow you to continue and then ask questions, or can we just respond to these questions in writing? So I don't know, because 26 is a long and a lengthy process because we use it now a lot. Maybe we can park it and we can have, I see that there's a lot of section 14 questions as well in the comment section. Maybe we can have a webinar just on section 14s. And because I think that there's a lot of questions on that. Zarina?
Yes, Corlia. So I think that what we and some of the colleagues have asked for it, and we did discuss it earlier on, that we will do a Q&A, right? I think at the end of the 4-day session, and send it to the attendees if that's what they want. And if people want to be excluded, please just drop Sansha an email to say we don't want to receive it. But that is what we will be doing at the end of the session. Sorry, I don't know if I'm working off a different agenda, but I actually thought that the time actually came to an end for this session. Sansha, could you maybe also just guide us on that?
Because on the agenda it was 11:25. Yeah, so I see here Saki indicated that they will prefer a separate section for a webinar for 26s, and maybe we can also think about a separate section just dealing with section 14s. We are in a process of writing a information session on section 14s, and then maybe when we issue it, we can have a webinar on that. But yeah, maybe Tando, maybe just address, we can do 26s on at the end, but maybe just do the principal officer. Because I think the principal officer is important, and then treating customer fairly, I think maybe just highlight on the principles.
All right, how much have I got? I've got 5 minutes, isn't that right, Corlia?
Yeah, so maybe just do the principal officers, and then we can have maybe a session on the TCF principles, also a separate one.
Okay, fine. Thank you. At least I get to escape the questions. Questions is a very lonely place to be. but anyway, speaking of the principal officers, I know there are colleagues here who are in the business of dealing with that better than I do. But obviously, the principal officer is an officer of the fund, and that is the definition in the Act. It is an officer of the fund. The principal officer owes a fiduciary duty to the fund as the board does. It has got a duty of loyalty to the fund, and though the principal officer may sit on the board, obviously the principal officer may be a board member in terms of PF 130, but may not be the chairman, or may sit on the board without voting if he is not a member of the board. And it is obviously appointed by the board and accountable to the board and the fund. But one thing that is important in terms of Section 8 is that the principal officer must, upon employment, there must be a clause there built in to say that if the regulator or the FSA does not approve of the principal officer, then the principal officer, or objects, sorry, because approve is a loaded word in this context. If the regulator objects to the appointment of the principal officer, then the principal officer's job may be terminated. That's just to safeguard the fund from any legal, ramifications of terminating the principal officer's job. Obviously, the principal officer is the FSA may object if there is a reason to believe two things. One, that the principal officer is not fit and proper, or no longer fit and proper where he is already appointed. Obviously, there must be a rational reasons for that belief, because it's an administrative decision which the regulator will not exercise willy-nilly. It has to be a sound basis for believing that a person is no longer fit and proper, giving him the right of hearing that is contemplated in PAJA, and advancing reasons and making him heard, and then removing them. Or where is no longer in the public interest. Public interest is a very tricky horse to ride. It is easy to understand what is in the public interest, but the courts have said public interest is that which would be good for the public if it happened or did not happen. I think, ladies and gentlemen, I can put it no higher than that. The principal officer obviously has statutory duties that are set out in the acts, elsewhere in the guidance notices, including, for instance, signing documents during a Section 14 transfer, confirming the veracity of documents during a evaluation that the evaluator relied on credible information, and also communicating to members amendments to the fund rules 6 months after every end of financial year. Then there's whistleblowing obligations, which the principal officer has in respect of the fund to the regulator, where, in the opinion of the principal officer, something is amiss within the fund, then there's an obligation to blow the whistle. Obviously, this is in the subjective opinion of the principal officer. The Act does not say what matters are reportable and some such, but obviously, as a person who's been appointed as being fit and proper, it would be in the discretion of the principal officer, or it will be obvious to him what prejudice may flow from certain actions within the fund that may be prejudicial to those members and the fund. And yeah, basically that is Corlia. Obviously, where there is reprisals, for instance, yes.
No, thank you, Tando. And I think what we must take the whistleblowing obligation, it's not a nice to have, it's a must. So if a principal officer is actually get to know about a matter that will have a detriment effect on the membership, they need to report it to us. So we are at the end of our session, and I think Emmanuel's hand is up. Maybe we can take, Zarina, if it's allowed, can we just maybe have one question?
I think it's fine. Emmanuel has had his question up for some time. Corlia, thank you.
Yeah. Emmanuel?
Emmanuel, I've enabled your mic. Please unmute
Okay.
yourself.
Can you hear me? Can you hear me?
Yes.
Yes, we can.
Yes. Yes. Thanks very much. The gentleman there, Mr. Mbono. You are so vocal, in terms of, presenting the what you call the rules and regulations. I think we are so fortunate to have a person like you to make a presentation to us. So my question here is that will we understand, will the question be relevant to say, who is actually the new trustee member? New trustee member means somebody who has never been a member of the trustee before. And my question is, who evaluated him to become a trustee member? as we are sitting here, taking from what Mr. Mbono presented to us, a trustee is supposed to be somebody who is so, you know, a good person, somebody who's knowing what is he doing in terms of the rules of the fund. It cannot be somebody who doesn't know the rules of the fund. And now, if anything wrong, based on the coming new trustee member starting the new job as a trustee, if anything wrong in terms of the rules, as that person is completely new, he hasn't got any idea of what is the rules of the fund. So do we still, that person taking, I mean, what do you call it? The rules still being gonna punished for the wrongdoing as a new member of the fund. Thank you, Mr.
Thank you, Emmanuel. Kinder words were never spoken. My boss is listening. So, but to come back to your question, Emmanuel, the act as I had presented gives you 6 months within which to acquire those skills. That's what you have, and then there's an obligation continuously to upgrade yourself. What motivates members when they are electing trustees or nominating them is a question that I cannot answer, because you do not get approved other than being nominated by your peers who see you that you could stand in the fund and be a member elected trustee, seeing to it that their interests are protected in terms of the rules. So what they see in you is I don't know, but once you are inside, the act gives you 6 months to get up to speed and continue to upgrade yourself. So if you have committed a breach of your duties while you are still wet behind the ears, I don't think that is an excuse or a defense that I'm actually failing you, especially after that 6 months period during which you must be up and running. In my view, perhaps members might want to revisit the criteria of the people, the quality of people, because people have different motivations to put people to boards. Some reasons are popularity on the floor, some other reasons, and you get there and you're out of your depth. Even after that 6 months, you're still struggling, and you don't have the diligence that the act requires you to perform those duties with. So if you offend against those duties, I guess it cannot be said that I didn't know. There's no such an excuse in law.
Yeah.
But obviously, if I may just, without wasting your time, Corlia and Sancha, if you looked at section 7F as I read it, it does make provision for the court to consider the circumstances under which you were elected and your bona fides in whatever infraction you may have committed. The circumstance of your election and your honesty and your reasonableness and your independence may mitigate against whatever liability may attach as a result. Thank you.
Yeah.
Thank you. Thank you for that, Emmanuel. We are more than willing to meet with you and to have an offline discussion. Tando, you know what? I think Tando will also be willing. I will ask Sancha to put our emails in the box, and then you can contact either me or Tando to set up a meeting, and then we can discuss this in depth. I just want to, we ran out of time. We've already taken 5 minutes over. We're already 5 minutes over our time. I just want to thank Tando for this wonderful presentation. I knew when I was paired with you, you know, we're going to have a ball. Thank you for making this interesting or difficult topic very interesting. And you can see out of the questions in the box that people enjoyed the session and you actually allowed them to think outside the box. But thank you, Tando. I appreciate this.
The pleasure is mine, Corlia, and thank you for the invitation. Cheers.
Okay, thank you so much, Tando and Corlia, for that educational session. And thank you so much for placing so much emphasis on, you know, the fiduciary duties of board members. I really appreciated the session, especially the real life examples from Tando and the interaction between Corlia and Tando on, you know, very important questions that Corlia was posing on, you know, definition and really understanding what the Act is saying. Without further ado, and I apologize, we are 5 minutes over time with the session. I will now hand over to Silindile Sebotsa and her mentor and her moderator, Johan van Vollenhoven, to do Module 3, Registration Rules and Rule Amendments.
Good morning, everybody. My name is Johan van Vollenhoven, and I'm an analyst in the Reviews and Authorizations Department, and my colleague Silindile will be doing the presentation for us today. Thank you, Silindile.
Thank you, Johan. Thank you, Sansha. Good morning, ladies and gentlemen. As Johan and Sansha have alluded, my name is Silindile Sebotsa, and I'll be taking you through the Module 3 of the Trustees Training Toolkit workshop. I will just put off my camera so that I can, you know, fully focus on the presentation. Thank you. My presentation will entail the following. I'll be focusing on the registration of retirement funds. I will also looking at the minimum requirements for the registration of rules, as well as the minimum requirements for the registration of amendments. I'll also just in brief speak on the registration of retrospective amendments and also the registration of consolidated and revised rules. Lastly, I will just also briefly discuss the binding nature of rules. Thank you, Sansha. We can move to the next slide. Sansha. Okay, thank you. So it is known generally that no pension fund can actually conduct a business of a pension fund without being registered and approved with the FSCA. This is actually provided for in Section 4, subsection 1 of the Pension Funds Act, which states that every pension fund must, prior to commencing any pension of a business, apply to the registrar for registration under this act and be provisionally or finally registered. So there are actually two types of registrations that may be granted to a pension fund. The first one is provisional registration and the second one is final registration. I will actually discuss these different types of registration as I continue with my presentation. Thank you, Sansha. We can move to the next slide. There are certain documentations and prescribed fees that need to be accompanied by the application. And these requirements are actually provided for in Section 4, subsection 2 of the Pension Funds Act, as well as Regulation 8 of the Pension Funds Act. And one of these requirements are the rules must be accompanied by a covering letter, which will include the full name of the fund, the physical address of its registered address, and the postal address. And the rules must also be accompanied by, next slide, the authority in terms of which the fund is established, and a duly signed certification, which is in terms of Regulation 8 of the Pension Funds Act. So usually the certification is compromises of a signature by the chairperson of the fund, the principal officer, as well as one other trustee. Then the set of rules which will be submitted for approval, and then the prescribed fee, which is provided for in Schedule L, which is currently an amount of 1,230. Regulation 30 also requires a format or the forms or contents which must be, adhered to. The first one are the minimum drafting format requirements. I will just list few. The rules must be printed in at least 1.5 spacing on an A4 paper, and they must be printed on one side. The headings and subheadings shall be in bold, and the definitions shall be printed in capital letters. Lastly, there should be no underlining in the rules. Also, the rules must reflect the full name of the fund. They must reflect the commencement date, also the physical address, as I've stated earlier. Also, the objects of the funds must be provided for in the rules, and there must be an alphabetical listing of definitions. Also, the rules must also speak on the exposition of eligibility. So we need to know who is eligible to be a member of this fund, and also the rules must state when this membership shall cease. And also the calculation and payment of contributions must also be provided for in the rules. So we need to know, and the payment and the calculation must be of recurring nature, meaning that it has to be done either monthly or annually. And also there should be a prescribed minimum benefits in terms of Section 14A of the Pension Funds Act. The rules must also highlight what are the benefits due to the members in instances where, for example, the member dies before retirement, in instances where the member resigns or the member gets dismissed or retrenched or becomes redundant. Also, there should be a provision in the rules which highlights rules regarding the alteration or amendment of rules, and also the manner and circumstances under which the fund shall be terminated or dissolved. The rules must also indicate what happens where there's a transfer or amalgamation of business between the fund and any other pension fund. There must also be an indication as to what is whether the fund is a standalone fund or an umbrella arrangement. As my colleague Julia has highlighted, we've got type A and type B. So the rules must also indicate, and all the other different types. For example, if the fund is actually a provident fund, the rules must state that. There must be also a provision which speaks on the processes that may be followed when there's an appointment of trustees. The rules must also indicate whether these trustees will be remunerated or not, and also the processes that may be followed in processes which may be followed where trustees are being dismissed. Also, the rules must highlight the powers that the trustees have. Thank you, Sanchia. While we are on the, the appointment of trustees, it is important to note that the Board of Trustees must at least consist of 4 members, 50% of which are member elected, and the quorum must be formed by at least 4 trustees. Thank you, Sanchia. In instances where you find that the fund actually cannot comply with the requirement that the board should consist of 4 members, then the rules of the fund must make a provision for the application of Section 7B exemption, where in terms of Section 7B, subsection 1, subparagraph A, the standalone fund can actually apply to be exempted from the requirement that the board should consist of 4 members. And in case of umbrella funds, the board may also apply for an exemption in terms of Section 7B, subsection 1, paragraph B, where the fund will then apply for an exemption to be exempted that the members must have the right to elect 50%. So this should be provided for. We cannot approve any exemption application if the rules do not make provision for the application of Section 7B exemption. Thank you, Sanchia. The rules must also highlight the appointment of officers of the fund, which are the appointment of a principal officer, which is the requirement in terms of Section 8, subsection 1 of the Pension Funds Act, and also the appointment of the auditors, which is also a requirement in terms of Section 9, subsection 1 of the Act. And then where the fund is actually required to appoint a valuator, the rules of the fund must also make provision for the appointment of the valuator, which is in terms of Section 9A, subsection 1 of the Pension Funds Act. And the approval should also be in terms of the Income Tax Act, which requires that membership in the fund must be by a condition of employment, and also that the contributions must be of recurring nature, like I've alluded earlier, that they need to either be made monthly or annually. Back to, okay, once the fund has actually complied with all these, the rules have complied with all these requirements that I've mentioned, then a registration may be granted in two ways. It can either be provisionally registered or finally registered. So the fund may actually register the authority may register a fund provisionally once all the requirements have been met and the authority has satisfied that it is in the desirable public interest in terms of Section 4, subsection 8 of the Pension Funds Act, and the rules actually comply with the minimum legislative framework. Provisional registration is actually valid for a period of 5 years, and it may be extended for a period of 12 months at a time. Another registration that may be granted to funds is final registration, which occurs once the authority is actually satisfied with the fund's financial soundness, and once all the conditions listed in Regulation 8 have been met, which are the rules must be consistent with the Pension Funds Act and the regulations, and the rules must be based on sound financial principles. So once the rules have been approved, a letter confirming registration, which is an approval letter, will then be forwarded to the fund, and also a certificate of registration with the rules bearing an endorsement will be forwarded to the fund, which is actually a requirement in terms of Section 4, subsection 4 of the Act. So usually the registered rules will be stamped bearing the date in which they were registered and signed by the analyst who was responsible for the registration of those rules. So upon registration, a fund becomes a body corporate, meaning that a fund may sue or be sued in its name. So basically a fund becomes a legal entity. It can be sued and can sue in its name. And then the affairs of the fund are actually managed by the trustees. And the fund may only conduct a business of a pension fund and nothing else. And lastly, the rules of the fund become binding in terms of Section 13 of the Act. The changes to these rules may now only be affected by way of an amendment, which has to be submitted to our office for approval. Moving to the second part of the presentation, which speaks on amendments. The funds are actually required in terms of Section 12 of the Act to amend their rules in a manner that is directed in its rules and adopt a resolution to that effect. They need to lodge such resolution with our office, which is the FSCA, for registration, and pay a prescribed fee of 415. No amendment may be valid unless they have been registered and approved by our office. Section 12, subsection 2, read together with Regulation 24 requires that amendments must be submitted within 60 days of passing the resolution. I think this is very important to take note when funds are actually dealing with the registration of amendments, to ensure that they actually submit the amendments for registration within 60 days of passing the resolution. And also the 60 days does not exclude holidays or weekends. So it is very important to note that it is actually a requirement that we look at when we deal with registration of amendments. And also the amendment or the application must provide us with a statement explaining the necessity for the amendment. So we need to know what are the reasons for these amendments. We cannot approve an amendment without knowing what is the real reason behind amending the rules. So the statement has to be included in the actual amendment which is submitted for approval. A certificate is also required certifying that the relevant resolution was adopted in line with the rules of the fund. And this is in terms of circular PF number 81. As I've said earlier, the certification will then include the chairperson's signature, the principal officer's signature, and one other trustee's signature. Thank you, Sanchia. When working with amendments, the authority, which is our office, may request any additional information should it be necessary. And the funds are actually required to furnish the authority with these the information required within 180 days. So failure to furnish this office with the required information will then result in the application for the registration of the amendment lapsing. The registration then occurs only when the authority is satisfied that the amendment is actually not inconsistent with the Pension Funds Act and it is actually financially sound. The words inconsistent with the Act had created a lot of confusion, and I will just, which resulted in it having two different meanings. I'll just cite two cases where this definition was actually dealt with. The first case is the National Tertiary Retirement Fund versus the Register of Pension Funds. This is a 2009 case. The Supreme Court of Appeal held that an alteration can only be inconsistent with the Act if it conflicts with the terms of the Act. So basically in this case, the court was actually emphasizing that when we deal with rules, drafting of rules and registration of rules, we only need to look at the provisions of the Pension Funds Act. While on the other hand, in Security Employees National Provident Fund versus the Registrar of Pension Funds, this is a 2017 case, the court held that the Act does not operate in a bubble of its own, and therefore it is part of the wider landscape, meaning that when we deal with the interpretation and also the drafting of rules and amendments, we do not only have to look at the provisions of the Pension Funds Act, but we also need to look at the other relevant South African legislation, such as the Income Tax Act and also the SARS practice notes. So it is therefore the duty of trustees to make sure that the amendments and also rules, the contents of the amendments and rules actually comply with the Pension Funds Act and also all the relevant South African legislations. Once an amendment has been registered, it takes effect from the date of registration unless the fund has determined its own effective date. So while we're still on effective dates, it has to be noted that there are actually amendments which have backdated effective dates, and these are actually retrospective amendments. So Section 12, subsection 1 prescribes that retrospective amendments are permissible if it does not purport to affect or intend to affect any right of a creditor. So we can only accept a retrospective amendment only if it does not have any negative impact on the rights of the creditor or on the benefits of the members. An amendment, a retrospective amendment cannot affect any liability to pay contributions which become due, and payable before an amendment was registered, regardless of the date the resolution was passed. So where in instances where we find that there's a submission of an amendment which came into effect retrospectively, we cannot accept such amendment or approve such amendment if it will affect the liability to pay contributions, irrespective of whether the resolution was taken after the effective date. So there are instances where you'd find that the retrospective impact succeeds and also the retrospective impact fails. The retrospective impact succeeds where the fund may reduce benefits before they accrue to the member. So we may approve a retrospective amendment where the fund reduces benefits before they actually accrue to the member. However, retrospective registration of amendments may fail in instances where you find a right or benefit has accrued before an amendment was registered. Therefore, meaning that an amendment cannot have a negative impact on or effect on the vested rights of the members. And also in instances where a right or benefit accrued after the amendment was registered, a member may escape the impact where he was not informed or notified of the amendment before it was registered. So the last part, I would like to emphasize that it's important for funds as well as employers when they actually amend rules to notify members of these amendments before they can actually submit them for registration. So the last part of this slide actually emphasizes that you need to communicate with the members in instances where you submit an amendment which will have a negative impact on their benefits. I'll then move to the third part of my presentation, which speaks on consolidated and revised rules. So consolidated rules are a consolidation of all registered alterations into a general body, meaning that consolidated rules may not introduce any new amendments. It is just a collection of already existing or approved amendments. It is actually our duty as the authority in terms of section 12, subsection 5, to make sure that when funds submit consolidated rules, there are no new alterations introduced. Some of the reasons why it might be necessary for a submission of consolidated rules is because you'd find that there's a difficulty in cross-referencing in the rules of the fund, and you'd find that when you want to refer to certain parts of the rules, you need to now go back and look for amendments, which causes a lot of difficulty and uncertainty, and which also raises a lot of queries, which may also be unnecessary. Anshia, thank you. And then there's also a registration of revised rules. Revised rules are a revision of the entire body of registered rules by alteration, rescission, or additional rules, and are dealt with under section 12. So compared to consolidated rules, with revised rules, we can actually accept the introduction of new alterations or new provisions into the rules. So unlike consolidated rules, revised rules are actually allow members to now submit new alterations, which will now be registered and turned into one rule under the revised rules. Apologies. So once registered, both the consolidated and revised rules take effect from the date of registration, unless the fund has determined the effective date of the rules. I will then come to the last part of my presentation, which speaks on the binding nature of rules. The rules are actually binding in terms of Section 13 of the Pension Funds Act, and they are binding on the members of the fund, the shareholders, the employers, and all the officers that I've mentioned, which are the trustees, principal officers, auditors, and valuators. In Sasol Limited versus Chemical Industry National Provident Fund, the court held that the rules of a fund form its constitution in that they govern the powers and responsibilities of the trustees. So meaning that the trustees' powers and responsibilities are provided for in the rules, and their trustees may not act outside the scope of the powers or responsibilities that are provided for in the rules. Thank you, Sancha. In Security Employees National Provident Fund versus the Registrar of Pension Funds, the court held that it is actually important to note that the binding nature of rules are not absolute, in that members may raise a defense on the binding force of the rules if they were not properly notified and the rules purport to reduce accrued benefits. This actually goes back to the emphasis that I made that it is very important to actually notify members of any changes that may be effected by way of amendments, especially if they're going to affect their benefits, and also where an amendment purports to reduce accrued rights. Lastly, in Mshika versus Mine Employees Pension Funds, the pension funds adjudicator highlighted that the trustees may only do with the fund's asset what is set forth in the rules, and that the rules of a fund are supreme. It is actually confirmed by Section 13A of the Act. So basically, the trustees cannot decide what to do with the fund, with the assets of the fund. They need to be directed by the rules of the fund as to what happens with the assets and the liabilities of the fund. And then lastly, the fund may not import any other provision outside of the registered rules and enforce them as binding provisions if the authority has not considered or registered them. So basically what this means is that there are no provisions that are foreseeable or binding to the members or the employer unless they are actually registered and approved by the FSCA. In closing, I would like to say, I think it is important to note that when drafting new rules and amendments, we need to make sure that the contents of the rules do not only comply with the Pension Funds Act 24 of 1956, but they also comply with all the relevant legislation. Thank you.
Thank you so much, Silindile, for that informative session. And thank you for highlighting the requirements, when it comes to registration and rules amendments. I really appreciated that. Johan and Silindile will now take a few questions. So if you could please raise your hand and I will enable your mic if you have any questions. Mr. Govender, I have allowed your mic. You can unmute yourself.
Yes, once again, thank you very much for the informative presentation. It's just a question of clarity, because you heard correctly, you said that it was mentioned that a member can challenge the rules for it not to be binding if there was no communication to the member. And I accept that that is correct. But how would one then determine communication? Because most of the funds have the tendency of just sending out notice to members, etc. And if the member says, no, I was not dissing out, because does it mean that I've got to send it in the member's personal capacity for to say that this? Because you normally send a notice to the company and you're not sure whether the company has put the notice up, etc. But you would normally take it that no, the company, the members are aware of the rule amendment, etc. Now, how do we maneuver that? Because that might create challenges if members are going to just come up and say, because at the moment there's a challenge, obviously, even if they've been made known of the rule, they're not going to openly say we made known of the rule. I think we use that as an excuse to say that we did not know about the rule. So I'm just seeking some clarity there. Thank you.
Thank you very much for that question, sir. Yeah, it's actually a very difficult question when it comes to communication because, you know, in big funds, it could be assumed that everybody can't be communicated on the same day. But it must just the fund must just make sure that reasonable communication are sent to members. Members should actually be aware there is a fiduciary duty on trustees to communicate any changes as alluded in Tando's presentation, that members must be made aware of any changes to the rules of the fund, any changes in their benefits. They must be aware of those changes. Thank you.
Thank you so much, Johan. Next is Ms. Angie. Let me just allow your mic. You can unmute yourself.
Thank you very much for allowing me a space to raise a question, and really do appreciate the informative presentation that you just gave. I'm carefully listening since the beginning of all these presentations. Clearly, and I think it's correct to hold trustees or board members liable for everything that they are doing. And I earlier had one raising a question that talks to a fairly new 5 cents of or a new trustee who's fairly new should also be having a knowledge as to what should transpire. But I don't hear any of the presentation talking to us about those who are given authority by the courts or the FSCA itself to manage in terms where trustees has defaulted and the authorities find that there's a need for someone to intervene. Now, if 12 people, for an example, or 8 people has defaulted, then one individual kicks in to come and make corrections. I don't hear FSCA or anywhere in the legislation that says, how are we going to hold that individual liably on whatever that may go wrong during the term of that individual when administering the fund on behalf of in the absence of the trustees. And you mentioned number of cases or anything that may have arises from different funds. And we all know we read them. But I really getting more worried because as trustees goes back into their funds, they find that there are many things that has happened, but there's no one to be held liable. And I just want to get it from this because I thought I'll raise it in the previous session. And unfortunately, that was too long. Could not have enough time to raise questions. Then I thought maybe on this, it may have that, because you find that the curators, for an example, during their term of office, they also make rule amendments that create more difficult operation for those who are coming after they left. How do we hold them liable and how do we monitor them prior leaving the institution when is relieved towards the rightful owners? Thank you very much.
Reggie, thank you very much for that question. I think if I understand your question correctly, it goes back to where a board is not properly constituted or cannot effectively do its duties. Then in terms of 26(2) of our Act, we've got the power to appoint trustees to that board. But as stated in the previous presentation by Corlia and Tando, I think they will have a separate presentation on that requirement when it comes to 26(2)s. I hope that answers your question. But if your question relates to that part of you know, where boards can't effectively do its duties, it will, you can contact Corlia's team regarding that. Thank you.
Thank you, Johan. I just want to give Corlia, Tando, Zarina an opportunity to also attend to this, as this related actually to the previous presentation.
Sancha, perhaps I can, or Tando, do you wanna take it?
Yes, I'll just take, if I may, I'll take the first step. I'm sure you'll deal with the rest of the issues. Boards are supposed to have a code of conduct, if I understood the question correctly. Boards are supposed to have a code of conduct that sets out and give them powers to discipline their board members, and there must be repercussions for the manner in which they act. That's the first thing. So it's not like boards are powerless against a board member that is doing his own thing. That's the first thing. And secondly, there are regulatory interventions that the FSA may make if, as we said, that we're made aware of those, by way of whistleblowing powers vesting on other board members. And where the authority is satisfied that the person is no longer fit and proper, they may be removed from the board. Obviously, depending on the infraction, and there may be penalties that may flow from that. So if I may just leave it there for yourself and Zarina. Thank you.
Yeah. So I think for Angie, your concern is your fund, and I suppose because now we sort of know which fund it is. Your fund was or the fund is under curatorship, and there were certain things that as the board came in now, they found that there were things that they believe the curator perhaps might not have handled properly. I think the most important thing that you need to bear in mind, especially for any board here, for that matter, we register a rule based on the fact that the trustees or the fund are saying that this is how they would like to manage a particular section. And you would have heard Silindile list, the cases that she cited. There are certain parameters within which we will then approve something. The practical application of that rule is something that will not necessarily be something that we're aware of. So say, for instance, you say to us, you are going to get tracing agents. I'll make an example of that. You're going to get tracing agents. Now, we've allowed or made a provision for you to do that as a board, for you to go and get tracing agents. Now, if you as a board then use that as a free-for-all to get tracing agents with no control of how they are going to charge, with no control over who those companies are and all of those things, we won't be aware of that. So as Tando said, you need to, if you feel as a board that there are things that somebody else did, whether that's a trustee, a curator, a service provider, anything that comes to your attention that you feel was prejudicial to the fund or and its members, then you need to bring that to our attention. Please do not work on the assumption that this person, even if it's a Section 26 board, that this person was approved by the FSCA and therefore we know the nitty-gritty operations of the fund and we approved them doing this and therefore we know. We don't. We will approve a rule because it's there in terms of legally this is what you're saying you want to do. But the operation thereof and how it's actually applied is not something that we would be aware of. There are other acts that are applicable to the duties and responsibilities and how we can hold curators or statutory managers and any other person that we're able to appoint in terms of the act responsible, such as the Financial Institutions Act, and those govern what can be done. But as you've highlighted, if there's things that you feel were not done properly or are causing a problem now as you come in, you need to bring those to our attention as a board. It is not it's not a nice to have. It actually says potentially, that you feel could potentially so you don't have to have it as a fact. You don't have to have it as, it must be in your opinion, Angie, you feel that what was done is prejudicial. You have a duty in terms of the act to bring that to our attention. Then we will investigate it. We will then have a discussion with you, whether you bring it anonymously. There's also protection against protected disclosure, so you could bring that to us anonymously or whatever else, and then we investigate it. But don't then sit back and say, but the FSCA appointed this person and therefore they should be aware of what they're doing. We do not have that level of oversight over funds. It is just impossible over all of the funds that we regulate for us to know every member record, every fund credit, every service provider charge and fee is correct. That is why the fund, it's so important for you to have the right reports and the right information in order for you to do the job that Tando was saying is tasked upon you. So please make sure that you bring those matters to our attention. Otherwise, we will not, we might not ever be aware. And that is it's just a limitation of how we supervise and we regulate, but you must understand it will be impossible for us to regulate at individual member level. Otherwise, then we wouldn't need a board and we become a super regulator and we make decisions for you, which is not what we want to do. Thank you.
Thank you so much. I'm answered and I'm covered.
Thank you, Angie. And thank you, Taki and Tando and Johan, for your feedback. This is the benefit of having representatives from the entire retirement funds division so that we can, respond to all of your questions. I just also want to give Zarina an opportunity because I know I saw her hand.
No, I think that I'm covered, Sansha. I just also wanted to say, and Angie feels covered, I think, but I also just wanted to indicate to Angie that, the curator, you refer to a curator, Angie, and I suppose it's applicable to your particular fund. Remember that the curator simply steps into the shoes of the board, essentially. So the curator still owes a fiduciary duty to the fund. And I think Takalani has probably covered you to say that where you've seen violations, breaches, please bring it to our attention so that we can address it. But thanks.
Thank you so much, Zarina. I note Lazarus, Reggie, and Emmanuel's hands. I will take it in that order. So I'm just going to allow Lazarus' mic. Lazarus, you can unmute yourself. Lazarus, you can unmute yourself. Okay, while we wait for Lazarus, let me allow Reggie's mic. Reggie, you can unmute yourself.
Sanshia, can you hear me?
Yes, I can. Thank you, Reggie.
Great. Partly covered by Johan, but I just need some clarity, and excuse my ignorance here, I'm still a new trustee, but having sat in other governance structures, I just find this a bit irrational. But I need some guidance. Firstly, in umbrella funds, what will be the rights of members to be represented in the board? That is the fundamental principle on which my question is raised, because we've got this board represent different employers, and surely each employer would like to have somebody sitting in the board so that, they are kept abreast of any changes that might happen that might affect their members. And now, if then the amendment in the board then looks at reducing the board, which it might be understandable if you say that the board is too big, for example, so you need to reduce the size. But surely you cannot do that at the expense of excluding other employers, because in this particular case, you've got other employers who have 2 people representing them. And then you then have 2 minority employers who have been excluded completely. Surely that can't be fair. Why should these other employers have 2 representatives if the board is too big, number one, and then at the expense then of just excluding 2 minority employers? So how can that be rational? And what is the role of FSCA when that kind of a rule is presented to them? That is my question, Sancha.
Thank you, Lazarus. Johan?
Thank you, Reggie. That's actually a very wide question because the fund is governed by the rules of the fund. And in certain umbrella funds, we have like the big umbrella funds where the sponsor will appoint all the trustees. And then you will have to have an exemption in terms of 7B for that, because members don't have the right to elect 50% of the board members. In some umbrella funds, a board can be constituted, but 50% employer, the sponsor trustees, and then 50% can be elected by the members of the fund. So it depends on how the rules of the fund is drafted, because Section 7A gives members the right to elect 50. So there must be direct elections. If that cannot happen, we need an exemption and reasons why that cannot happen. But I understand your concern that maybe bigger participating employers will have bigger election rights and then smaller ones will be excluded. So I think we can have an offline discussion on that because it seems like it's a very complicated matter when it comes to how the board will be constituted and how members will be represented on that board. So you are more than welcome to send me an email. I will put it in the chat box and then we can take it from there. I hope that answers your question.
Brilliant. Thank you very much. Muchly appreciate you, Johan. Thank you. Thank you, Sancha.
Thank you, Reggie, and thank you, Johan. Let me just see if I can get Lazarus again. Lazarus, can you unmute yourself?
Yes.
There we go.
I think I can now. My question relates to the application of Section 12.2 with regards to the rule amendments. What normally happens is that, we know that the amendment needs to be submitted within a certain period. I think it's 60 days, of the date of the resolution. But what normally happens is that after the amendment has been submitted, your office will then raise queries, and some of those queries will necessitate, the submission of a replacement rule amendment. So when you submit the replacement rule amendment, in the replacement rule amendment, you will
Lazarus? I think we might have lost him again. Yeah, I think I'll just go to Emmanuel and then we'll just check on Lazarus after that. Emmanuel Avelar, your mic, you can unmute yourself.
Thank you, sir. Thank you, ma'am. Thank you very much. I'm not sure if the answer I'm going to ask is being responded, but let me ask that answer the question. The question is that earlier it was presented by Mr. Mbono that the fund or the money has to be paid in time by the employers. Now, the question is that we are having that rule and we normally taking a strong actions against those employers who are failing to comply. Now, I'm not sure if there is any other rule which can replace the current rule, which we think it's a rule that everyone has to abide by. Then the other question is that you find that you have the trustee member. As a trustee member, at the same time, you got that trustee member, an employer on the other side, and is also involved or failing to comply with the rules of complying in time in terms of the rule required. So I just want to find out, how do we deal with that matter? Is there any way that we can get an assistance in that? Thank you.
Thank you so much, Emmanuel, for that question. Johan, would you like to provide feedback? I think Emmanuel's question is related to the first presentation.
To the second one.
Yes.
Julia and Takalani.
Quite
so
right.
Maybe I can just give Julia and Takalani an opportunity to respond.
Yes, the 13A issue has become has always been problematic. I think the thing that is exasperating it might be the fact that, you know, the solutions that were previously provided and the options that were provided were not necessarily effective. So as I indicated previously, we are doing webinars on Section 13A. The next one is the Bargaining Council one, and then we'll do commercial umbrellas. But I think your issue relates to how effective would it be to have someone on the board that is also not, you know, that's also an employer but is not contributing or is not doing anything in terms of responding. One, there is a duty to report such matters to the FSCA. We do have a process online and also a dedicated mailbox for those queries. And we have taken a very, I want to say, a hard stance against the trustees in some instances to say it's your duty to make sure that you do everything possible for you to recover such money. So have you reported it to the Pension Fund Adjudicator's Office? Have you taken any legal action? And we are reviewing those matters as well. And you'll see the conduct standard is now more aligned to opening a case. But I understand that there's still some teething problems that we need to resolve with reporting the matters to the prosecuting authorities as well. So I would say bring that to us because we do have funds that have sent through and are required to, in any event, report those matters to us. And where you feel that there is there's a conflict, and I think that was Tando's presentation as well, where you feel that there's a conflict in that employer, being on the board and also, being the person that is responsible, then you need to raise that as well. You need to be able to say, because the Act actually requires that the trustees avoid conflicts of interest. So where you feel that that conflict is impeding you from performing your duties, your fiduciary duties, then you certainly have a responsibility to raise that as well. It's a very tricky situation. I know the balances are, whether you put the employer out of business or if you then pursue the arrears. We understand that it's a very delicate situation, but the trustees are tasked with the duty of recovering the monies. In respect of, I think your initial query was also about representation on the board. And I think Tando could perhaps take that, because there was he made a very good comment about how to take the right away from members, or the right from members being taken away from them to exercise their to be able to vote for trustees. And I think that goes towards representation. So perhaps Tando, you could just expand on that. I think the issue is, in an umbrella